Welcome back, Mr. Smith. I want to start by addressing or starting on the issue about the collection of call records related to certain members of Congress. You recall the majority asking about this at length in their first two rounds so far today?
Yes.
Did Donald Trump and his co-conspirators try to reach out to members of Congress before January 6th and on January 6th of 2021?
Yes.
Can you tell us a little bit about what your investigation uncovered regarding communications with members of Congress that's related to the attack on the Capitol on January 6th?
There was pretty extensive contact with members of Congress. There were instances of members of Congress, again, specifically on January 6th, but also before that, where either they were reaching out to the White House or the White House was reaching out to them, and through conduits to the president, including, as I said, Mark Meadows.
Okay. And what was the nature? Let's start with before January 6th. What was the nature of some of these communications with the White House or with co-conspirators of Donald Trump leading up to January 6th and members of Congress?
Well, it varied. Sometimes the communications were relevant to us to show that people were telling Donald Trump that the things he was saying were not true. Other times they were evidence of the false nature of the things that we're saying. So for an example would be, there are two voicemails that Rudy Giuliani left for senators, and those voicemails show him saying things that were not true, using knowingly false claims to try to get those senators to further delay the certification of the vote.
Now, you just mentioned that there were instances before January 6th of members calling the White House, and I'm summarizing, to basically express that some of the claims the president and his co-conspirators were making were not true. Is that what you just said?
Well, I should be specific. There were a variety of reasons that, and I'm not trying to say that any time someone contacted the White House, they were involved in a crime themselves or doing anything improper. But how this conspiracy that was trying to stop the lawful transfer of power, how that worked, it was important for us to understand. We had evidence from Department of Justice officials that Donald Trump said to them, just say the election is corrupt and leave the rest to me and the Republican congressman. I think given that was the perspective that Donald Trump had, our view is that the case we would have presented at trial would have been Donald Trump preying on the party allegiance of people in his party. And people like the vice president didn't agree to that. People like the elector from Pennsylvania I mentioned didn't agree to that. People like the Speaker of the House in Arizona didn't agree to that. But the extent to which those contacts were happening was relevant to our investigation.
Okay, so let's dig down a little bit in that. Let's start on January 6th. So I believe in the evening, did your investigation uncover or learn that Mr. Trump personally called members of Congress on the evening of January 6th?
Yes.
Do you remember who those members were?
I'd have to look at the records to be sure, but the best of my recollection, he was trying to get in touch directly himself with Senator Hawley and Senator Haggerty. And then there were several senators who he directed Rudy Giuliani to get in touch with.
And who were those senators that Mr. Trump directed Mr. Giuliani to get in contact with, to the best of your recollection?
To the best of my recollection, and this comes from a email, or I think it was a text maybe, that Boris Epstein sent to Mark Meadows, and it basically said something to the effect of the president told the mayor to call these senators and they needed numbers. And what our investigation ultimately showed was they sent that text after they'd already started trying to call members. and didn't think they had, and ended up understanding that they didn't have the right phone numbers. In fact, the message that they left for Senator Lee, which he voluntarily provided to our office, that was meant for Senator Tuberville, I believe. And the message that he left for Senator Sullivan, I believe it was for Senator, the name's escaping me now, but it was another senator that he meant to call. We had also interviewed Boris Epstein before these subpoenas were issued. He corroborated that they were, in fact, trying to call senators. He dissembled and tried to imply that the president hadn't directed him to do it, even though there was a text message saying specifically that they had. But he agreed that they tried to call these senators and that they had certain senators' numbers themselves, and so they didn't need those numbers. And that would be, I believe it was Senator Cruz, and possibly, I think he said they possibly tried to call Senator Graham as well.
Taking a step back, this might be obvious for a lot of folks, but just to make sure it's clear for the record, who was Mr. Epstein?
Boris Epstein was one of the co-conspirators in this case.
And what role did Mr. Epstein play in the larger conspiracy, if you can summarize it?
Well, he played several roles. He was involved in the fake elector scheme, and also in sort of pushing out some of these false fraud claims. The other thing, I'm sorry, just to go back to mention is we also, in the course of the investigation, interviewed Rudy Giuliani. And one of the things that we asked him, if you recall, in the message, and I can't remember which senator it was for, but in the message that he left, he said, referenced the fact that he was calling on fellow Republicans. And in the interview, we asked him, why did you say you were calling on your fellow Republicans? And he said, well, I wasn't going to be calling Democrats about this. Even some Republicans wouldn't go along with this. And so, of course, I would call only Republicans. And in fact, that was consistent with our investigation throughout, that the people that President Trump and his co-conspirators reached out to were people who they thought would go along or help them because of party allegiance. And Giuliani in particular would reference that he expected their cooperation because they were Republicans. There was one particular meeting that he attended where he got a hostile reception because he had no evidence to back up the fraud claims. And he said something to the effect of, I thought we were all Republicans here. And so that was a theme throughout the case. And it went to the strength of the case that we had because the witnesses we were going to call were the people that the president reached out to sort of further this criminal scheme.
I want to touch on a point because it seems like the evidence you uncovered showed certain members of Congress, including Republicans, pushing back on this assertion about the big lie. And I'm characterizing some of these claims about the election as the big lie. Is that okay if I use that term? Big lie?
You can use whatever term you like.
Oh, I'm going to use the big lie. So do you recall any evidence when you were talking to Mr. Giuliani that he truly believed all the voter fraud claims that he was putting out around the country?
Our evidence was he did not. And in fact, when we interviewed him, he disavowed a number of the claims. He claimed they were mistakes or hyperbole. Even the claim about Ruby Freeman, where he basically destroyed this poor woman's life by claiming she was a vote scammer. President Trump did the same thing in a recorded call with the Secretary of State. He disavowed things he'd said in that interview.
Thank you.
Can I ask a question? Were you able to interview some of the individuals that our January 6th committee was unable to interview? For example, did you interview Mark Meadows?
We did.
We were unable to talk to Mr. Meadows. Were you able to find out what the communication was between Mr. Meadows and Mr. Bannon and potentially Mr. Stone on the evening of January 5th at the so-called War Room at the hotel?
I don't recall that as I sit here right now. I know Mr. Meadows spoke to a number of people who were either involved in or adjacent to this conspiracy. As I sit here right now, I don't recall that specific evidence. I think he was in touch with Bannon, but I don't recall specifically the answer to that question.
Mr. Bannon made an extraordinary video basically predicting the events of January 6th on the day before. Were you able to discover, either by interviewing Mr. Bannon or those who had knowledge of what he was doing, how he was aware of the riot before it happened?
We did not interview Mr. Bannon. I believe that particular statement you're talking about would have been part of our proof, and my recollection is that we had evidence that would indicate from some point, not immediately after the election, but shortly thereafter, sometime, might have been closer to December period, that Bannon, who had been out of touch with President Trump for some period of time, got back in more regular touch with him at some time. And in fact, this is reminding me, my recollection is that we had a text thread that between Bannon and Epstein that went through a lot of this period. On that text thread, I believe it was the evening of January 6th, right around the time the senators' calls were occurring at the direction of the president. And there was an exchange between those two wherein I believe it was Epstein asked Bannon, "Are you in touch with him?" And the answer was affirmative, and it was something to the effect of, "He's still on fire." And that's right at the same time that these calls are happening, after he refused to do what he could to stop the attack on the Capitol, after the tweet about Mike Pence.
In December, there were several meetings in the White House where efforts were to overthrow the election were discussed in terms of the fake elector scheme. The president issued his tweet calling the mob to Washington that it would be wild. Did you identify members of Congress who participated in any of those meetings
Participated in meetings at the White House.
in December?
I'm thinking now, I can't say that we didn't, but as I sit here right now, I can't think of a member of Congress in particular that attended the meetings I'm thinking of right now. Not saying it didn't happen, I just don't have a
I want
recollection.
to follow up on that. There was a December 18th meeting. Do you remember a December 18th meeting at the White House right before President Trump then issued the "Will Be Wild" tweet in the early morning of December 19th? Do you remember I believe Ms. Powell was there and others were at the White House discussing with Mr. Trump?
I remember there was a meeting with Sidney Powell where there was a discussion about whether she would be appointed a sort of special counsel to sort of have this role that would assist Trump in pushing these claims of election fraud that were false. My recollection of that is the meeting ended, I believe, with President Trump saying, "I want her in that position," but then it didn't happen because she didn't fill out the paperwork, clearance paperwork necessary for that. I don't know if that's the 18th, but it's around that time.
And do you recall any members, just following up on Ms. Laughlin's point, do you recall any members of Congress being present or participating in that meeting?
There's a record of this in our files. I remember certain individuals. I think Mark Meadows was there. An individual by the name of Eric Hirschman was there. I think Rudy Giuliani was there. There was a number of people there. I'm not remembering if there's anybody in particular you can ask me and I can see if I could remember, but that's what I remember now.
Who introduced the idea of Mr. Clark becoming Attorney General?
Our investigation determined that Congressman Perry had a role in getting Jeff Clark on the radar of President Trump as someone who could help him. and getting meetings with Jeff Clark and the president.
And we might touch on Mr. Perry's involvement later on. Just want to flag that for you. So it sounds like, and I want to hear it from you, did your request for the toll records of certain congressional members, did that relate to phone calls made to these members of Congress on or around January 6th of 2021?
Including that, yes.
And how big was the window of records that you requested for these members of Congress?
The records regarding those calls on January 6th, the period of time was from, I believe it was January 4th to 7th, but there was earlier subpoenas, including the one referenced earlier today regarding Congressman McCarthy. There was a broader period of time from, I want to say it's about November 3rd through, again, it was either January 6th or 7th.
And I've heard you mention evidence such as text messages with Mr. Epstein, Mr. Giuliani. Did you also have Mr. Giuliani's records as part of your investigation? Did you collect those? Phone records, I mean?
We did.
Okay. So in your prosecutorial experience, do you generally seek to obtain call records from both individuals involved in a telephonic call or message?
We do, and in this case, with the records for that evening, it was particularly important because when we interviewed Boris Epstein, one of the things that came out was that Rudy Giuliani had two phones and that Boris Epstein had another phone, and we needed to make sure that we weren't missing any calls in terms of where the calls came from. And so it would corroborate the records that we had, but also make sure that there's not calls that we missed.
Did you ever learn why Mr. Giuliani and Mr. Epstein had multiple phones?
No.
Did the toll records that you requested from the senators, did they include the content of the phone calls?
No.
Did the records that you requested, the toll records from the members of Congress, include the content of text messages?
No.
Can you explain for us on the record what information generally is included in a toll records request?
Sure. Again, my understanding from a prosecutor's perspective is it is non-content information. It's generally about when the call started, when the call stopped. That would include obviously the duration of the call and who the call is to and who the call is from. That's the basic information that you want to get from a toll records subpoena.
And let's fast forward to, say this would have gone to a trial. How would you, in your experience, have used this type of evidence in a trial?
Oh, it would have been relevant in a number of ways. So it would have been relevant. You could put it together in a summary chart to show the series of contacts, and it could be relevant to show the campaign that evening to reach out to senators to delay the proceedings. Could also be relevant to show, for example, on the afternoon of January 6th, of notice that there was notice that violence was going on. Congressmen, both Republican and Democrat, and the vice president were in danger. That text records would make that incontrovertible that those calls actually happened. They'd also be relevant for examining witnesses, whether it would be a prosecution witness who might not remember exactly when a call happened, or a defense witness, for example, if any of the co-conspirators were to testify, which, as I mentioned before, was something we would have welcomed. We would have had toll records to question them about the calls that they made, the calls that they received, things of that nature, which, in my experience, can be very effective.
Can I ask, we attempted in the January 6th committee to question Peter Navarro as well as Steve Bannon, and they were both prosecuted and spent time in jail. Roger Stone appeared but took the fifth. Were you able to provide, to get information from any of those three individuals, and in the case of Mr. Stone, provide use immunity so that he would have to testify?
We did not.
Why not?
We pursued the investigative routes that we thought were the most fruitful. We pursued those that we thought were necessary to get a complete understanding of the scope of the conspiracy. And given the highly uncooperative nature of the individuals you talked about, I didn't think it would be fruitful to try to question them. And the sort of information that they could provide us, in my view, wasn't worth immunizing them for their own possible conduct.
Okay, thank you.
Going back to the toll records, I just want to make sure we make a few things clear. When you were requesting toll records, did it mean that DOJ or FBI was conducting surveillance on members of Congress?
No.
When you were collecting toll records, did it mean that DOJ or FBI would be able to wiretap phone calls made by members of Congress?
No.
Yes,
Okay. I want to actually go back to some of the lines of questioning that you endured by the majority. There seemed to be this insinuation that there was a lack of respect for the defendant's schedule. Do you recall kind of some of that line of questioning?
I recall questions about his schedule, yes.
Okay. I just want to level set because this is going to be a record and it may be public one day. Considering all the years of experience that you have prosecuting, is it more often or less often that you've had a defendant that has been charged in 4 different jurisdictions with crimes?
I don't know if I've had that before, but it certainly hasn't been often.
Okay. And as it relates to these 4 jurisdictions, we know that he was charged not only on the federal level, but he was also charged on the state level, correct?
That's correct.
And in your experience, typically has it been that if you have a defendant that is charged in multiple federal cases that the federal magistrates or the sitting judges typically confer and figure out scheduling conflicts?
That can happen, yes.
Okay. The issue in this case, or a number of issues in this case, was not so much your prosecution, but was the fact that there was alleged criminal conduct all over the place, correct?
Well, I was focused on my case and my prosecutions.
Okay. So I guess what I'm trying to figure out how I want to do this because they were doing this a different way. Essentially, did it seem as if President Trump was actually enjoying privileges that the average defendant did not?
I certainly wouldn't want that to be the case. I think the law should be the same for everybody. I don't think anybody should be above the law. I think in a case like this, that could be challenging, but it was my goal to make sure he was treated as anybody else, as any of us would be treated.
So let me ask you this, because in my experience, I've never had a defendant have so many charges and not spend one day in jail. In your experience, have you ever had a defendant charged with so many cases and not spend one day in jail? And when I'm talking about a day in jail, I'm talking about pre-incarceration. What I was observing is that the president was experiencing walkthroughs for seemingly every case that he got instead of going through the typical process that a defendant would normally go through.
Well, I have to say in our cases, in terms of, we did not try our cases. We did not prove our cases in a court beyond a reasonable doubt. And so any sort of sentence, whether it would be incarceratory or otherwise, we never reached that point in the proceedings. And in our case, whether someone would be detained before trial, there's factors you look to for that. We did not ask for President Trump to be detained before trial. And so, as I think I've made clear, I wish we had been able to try these cases because I am confident we had the proof to sustain convictions. And I did try at every place to make sure he was not being treated better or worse than anybody else. But with respect to those things, that was the state of the record in our case.
You've tried cases on the state level, correct?
I have.
Okay. So he was charged in Georgia as well as New York. Are you aware of that?
Yes.
And in your experience in handling trial cases on the state level, typically, and correct me if I'm wrong, typically a defendant is incarcerated and then given a bail or not. to get out? Has that been your experience as it relates to trial level on the state level?
Depending on the charge, yes, and obviously the charge depends on what the bail level is.
Correct, correct. Okay.
I just have one more question about the toll records. So in this past October, in a Senate Judiciary Committee hearing with Attorney General Bondi, Senator Josh Hawley claimed that the subpoena of his phone records was, quote, tapping his phone. As part of your investigation, did you or anyone from your office tap the phone of Senator Hawley?
No.
So is his suggestion that his phone had been tapped just simply false?
It's inaccurate.
Okay, thank you.
I believe earlier, and we're turning back to January 6th, the conspiracy leading up, the events on January 6th, and I believe earlier you said that the reason why, and I'm paraphrasing here, that you charged the president was that he was the most culpable person related to the crime of attempting to criminally overturn the 2020 election. Do you recall saying words to that effect earlier today?
Yes, and because we had proof beyond a reasonable doubt and met the requirements in the federal principles of prosecution.
And I believe you said some of the false claims he was putting out created a certain level of distrust about the validity of the election of 2020. Do you recall saying something like that as well?
Correct. That's alleged in the indictment.
Great. So I want to start with how that level of distrust was created. In your report, you say, and this is a quote, the through line of all of Mr. Trump's criminal efforts was deceit, knowingly false claims of fraud. Can you generally describe some of these knowingly false claims of fraud that were spread after the 2020 election?
Sure. There's a number of them. And you know, part of the explanation is why they're false. And so, you know, just off the top of my head, an example is he was on notice in this election that in Pennsylvania, for example, that he would be ahead in the vote count for a period of time, and then when the mail-in ballots were counted, his lead would dissipate. He chose to represent that phenomena that he'd been briefed on, that was normal course of an election, that all sides knew that that's how it was going to be. He chose to present that as evidence of fraud. And to people who are not maybe as informed as him or informed as his campaign managers who told him these things, that's the sort of thing that creates distrust. There were fraud claims in, you know, Michigan, Georgia, where he was specifically disabused by people he trusted, by political allies, by the people when he chose to call them who are best situated to know. In Georgia, I'm thinking of the Secretary of State. He reflexively rejected those things and continued to state false things after he'd been told that repeatedly that they weren't true.
And why was it important? It probably goes to the mindset, but why was it important of all of these repeat statements from individuals that Donald Trump's claims were untrue? How did that play into your overall investigative findings?
Well, I think the pattern and the depth of the pattern and the length of the pattern was pretty damning evidence that he knew these things were false. He only brought fraud claims that involved states that he'd lost. He only approached people generally who had party allegiance to him. When he was told that a fraud claim wasn't true, he didn't stop making it. Another example I can give is that Sidney Powell, who's alleged as one of the co-conspirators, was part of his team at the beginning of this conspiracy. Shortly after, she began making statements that really nobody could credit, that were facially false. And at some point, Giuliani made a statement that she wasn't on the legal team anymore. And Trump, at one point, was on a call, President Trump, where he basically, if I recollect it right, he muted the call and said she was crazy. But then after that point, he continued to promote her fraud claims and lawsuits. He considered putting her as a special counsel, even though he'd admitted, you know, he used the word crazy, and the statement she was making could by any reasonable person be viewed as true. And so I think that sort of like claims that were so outlandish and so just fantastical, continuing to push those sort of claims after they've been disabused with strong evidence of our case.
It seems like the evidence that your case uncovered was, I think you said Mr. Trump contacting mostly or all Republican officials about his voter claims from the election of 2020. Is that correct?
That's my recollection. As I sit here now, I can't think of anyone who wasn't someone who was loyal to him politically. And again, many people who would have been our witnesses rejected his entreaties to do that. And again, I think it was in Michigan and in Arizona, and also the Attorney General in Georgia had stated, I voted for him twice. And others stated, I wanted him to win, I campaigned for him. So it's not as if it was effective in every place, but that was who he focused this at. And that's why I had said earlier today that the witnesses in this case, the subjects of the toll records in this case, those were chosen by President Trump.
So if President Trump would have pressured, for example, a Democratic state leader about these false claims of the election, would you have looked into that Democratic state member as well?
Absolutely.
You mentioned earlier talking about, individuals pushing back on these false claims. When you're talking about the fake electors, you mentioned a congressman from Pennsylvania who I guess would have been a witness who might have pushed back on the fake elector scheme being legal. Do you recall saying that earlier?
I do.
Who was that member?
My recollection, I think his name was Thomas Marino. He was a former U.S. attorney, and he's a Republican, former congressman, and he had agreed to be, and this is before the election, agreed to be an elector for Donald Trump. And when he was presented with this idea of the fake elector scheme, my recollection of his reaction was that this was an attempt to overthrow the government, and it was illegal.
You also mentioned a few of the states that Mr. Trump and his co-conspirators, such as Mr. Giuliani and Ms. Powell, targeted about these false claims about the election. Do you recall which states were the main targets of this group?
Yes, I believe it was 7 states. Let me count them. Georgia, Pennsylvania, Wisconsin, Michigan, Arizona. I'm missing one because New Mexico was memorable because he lost that by 10%. There's one more I'm forgetting.
Nevada?
Nevada, thank you.
And I just want to confirm Nevada was the last state. Is that
That's correct.
sir? Okay. Did your investigation uncover why Mr. Trump and individuals like Mr. Giuliani and Ms. Powell might have selected these 7 states?
Well, the states were all states that he lost by a pretty small margin, except for, again, New Mexico was 10%. I mean, depends what you define as small, but the others were all much closer than that.
And these states had all voted in support of Mr. Biden being president, is that correct?
Yes.
Okay. So just to be clear, Donald Trump had lost all 7 of these states, but it appears narrowly, depending on how you define narrowly.
That's correct.
One of the bigger parts of your report, and what you've talked about here today, comes down to the knowledge, Mr. Trump's knowledge that he had lost the election. I know you've talked about it at various stages of today, but I would just like a pretty clear answer, if you don't mind, about what evidence did you collect about Mr. Trump's knowledge that he had indeed lost the election of 2020?
Okay. Well, there are 2 types of knowledge. One, that he lost the election, and another, that the things he was saying, the fraud claims, were in fact false.
And I want to start with the first one, that
Yeah.
you said that he had lost the election.
Yeah. I think, again, it's the same sort of bucket of evidence that he was repeatedly told by people that the very fraud claims that would change the outcome were not true. As you may remember, when he was told by his campaign team, in essence, that if you can't win Arizona, you can't win the election, and then he'd lost Arizona, he changed out that team and went with Giuliani and his group. We also had statements from other individuals. I believe it was General Mark Milley who said he was going to leave this for the next guy. There was another staffer who overheard him saying something to the effect of, and I want to make sure I'm not inaccurate here, it's in our final report, but basically, like, you keep fighting regardless of whether you won or lost, things of that nature, which were corroborative of the very strong evidence of that the things he was saying about about the election claims were not true.
And then you said earlier when I asked you the original question, I thank you for parsing out the various knowledge, right? The second part was that Mr. Trump knew that his claims were false. And in the report, you say that Mr. Trump, and this is a quote, knowingly made false claims. So I'm assuming that talked about the false claims he made after he knew that he had lost the election. Can you describe or summarize some of these false claims he made to the American public after he knew that he had lost the election?
Sure. These would be false claims about dead voters. It would be false claims about underage voters. It would be false claims about illegal alien voters. The false claims were generally, as a general matter, about urban centers where he had lost the vote in a particular state that was otherwise close by a lot. Yes, and again, these were claims that were rebutted by people around him who knew that they were false, and in many cases told them they were false.
Can I go to January 6th itself? The president gave a speech on the rally, and we received information and testimony that a couple of things, that his supporters were leaving their weapons outside the magnetometers because they couldn't go through, and also that at some point Mr. Trump said, let them come through anyhow because they're not going to hurt me. It was subsequent to that knowledge that some of these supporters were armed, that he called on them to go to the Capitol. Was that set of facts subject to your investigation and review?
I recall what you're talking about. I remember we interviewed different people who were near or around President Trump in that period of time before the ellipse speech. And on that point, there were different recollections and different points of view. Some people said what you said. Other people had more innocuous explanations about why people stayed outside the magnetometers. Clearly, people did stay outside the magnetometers. You could see that in the video of the crowd. So I do recall that. And as I said, I remember different people hearing different parts of that and having different perspectives on it.
Metropolitan Police, as well as Secret Service, identified a number of people who were armed along the route, some of them in trees. Did you get information about that?
I don't recall. I do recall there were people who certainly had weapons at the Capitol. That I recall with certainty, and there's people who used weapons, whether they be poles or sticks or other weapons, against police officers. I know there was one officer who they took his gun. And so the use of weapons against members of law enforcement, it was outrageous, but it figured heavily in what happened at the Capitol that day.
Thank you.
I'm actually, if you don't mind, I believe it's Exhibit 10. It's your volume 1 of your report. I think we entered it as an exhibit earlier, and I'm going to direct you to page 39 of your report. And I'm going to focus on the middle paragraph. There's 3 different paragraphs on this page. I'm going to focus on the middle one that starts with Mr. Trump's intent in spreading knowing falsehoods. Do you see that paragraph, Mr. Smith?
Yes, this was this paragraph was what I was referring to when I spoke earlier.
That's what I thought. Did President Trump ever acknowledge, and I believe you talk about it in this paragraph, but did President Trump ever acknowledge that he knew that he had actually lost the election to President Biden?
Yeah, so this paragraph references different statements that he made in the presence of other people. One is that it doesn't matter if you won or lost the election, you still fight like hell. And then the other was, can you believe I lost to this effing guy?
So,
Referring to Joe Biden.
So if this would have gone to a trial, and using your years of experience being a prosecutor and a trial attorney, how would you have argued this admission to Mr. Trump? Or how could you? What's a way you could have argued this admission from Mr. Trump to a jury?
Well, I think I saw these admissions as corroborative of the larger case. We would have presented what I viewed as very strong witnesses from each state to explain how the elections occurred in that state and why the events, the outcomes were trustworthy, and debunking various fraud claims that President Trump made. We would have presented the false claims that he made repeatedly, interspersed with debunkings to him or other evidence that showed they weren't true and that evidence got to him. This sort of evidence would corroborate that, but it would sort of be the cherry on top, if you will. The evidence that I felt was most powerful was the evidence that came from people in his own party who, as I said earlier, put country before party and were willing to tell the truth to him, even though it could mean trouble for them. I think witnesses like that, in my experience, would be very powerful witnesses in front of a jury, and this sort of evidence that you're pointing to here would be extra, but I think those other witnesses would be very strong proof.
And I want you to elaborate a little bit on that, on your experience with these types of witnesses. I'm assuming, individuals from the same party as Mr. Trump pushing back on his assertions of voter fraud and various other claims. Why would that, in your opinion, have been powerful to present to a jury?
Well, I think someone who puts country before party, I think my understanding of people, of jurors, that people appreciate that. I know I certainly do. The other part about that is the reality of, like, when people speak out against their political party, there can be costs. And when people are willing to pay those costs because they believe in something, because they're going to tell the truth, I think people get that. And I think the witnesses I'm talking about, if I had to cross-examine them and make them not look credible, that would be very hard. I think that would be a very hard assignment.
You mentioned just now, as part of your trial strategy would have been, having individuals from each state come up and talk about their experiences, pushing back on Mr. Trump's false claims about the election. And one of those states you mentioned earlier was Pennsylvania. And so I do want to give Ms. Scanlon from Pennsylvania a chance to ask a few questions.
Thank you. Appreciate you being here, and certainly we were paying very close attention to this whole process in Pennsylvania, since Pennsylvania was one of the main targets for the president's attempts to overturn the 2020 election. Can you just outline for us what actions President Trump, if any, took in Pennsylvania, a state that Joe Biden clearly won, in the 2020 presidential election, to overturn its results and gain the electoral votes for himself?
Sure. Like the other 6 states involved, there were knowing false statements about fraud claims. You're testing my memory here, but one was, I remember there was a persistent claim that more people had voted than it had been given ballots. And it was a very clear thing that we were talking about 2 different elections, and there's email traffic among his staff and people who work for him about how obvious this wasn't true, and persistently kept making that statement over and over again. I also remember in Pennsylvania, the chair of the Republican Party in Pennsylvania, a guy by the name of, I think his name was Tavis, very shortly after the election, this is in, I want to say, mid to early November, disabused President Trump of the idea that the reason his vote total, his lead was going down, was because of fraud. And he explained again, that's how, we all knew that that's how this was going to work with absentee ballots in the state of Pennsylvania, which we had very strong evidence that Trump, in fact, had been briefed upon by his campaign staff. So those aren't the only examples, but they're the ones that come to mind as I sit here now.
You have a really good memory, but that first one you mentioned, the claim that there were more ballots being cast than had been issued, is one that some of our colleagues here have repeated, despite the fact that the entire state election apparatus has contested it for 5 years now. I think your report mentions the conversation that the president had with Larry Thomas, the chair of the Republican Party, in which he explained to him just a couple days after the election concluded why Pennsylvania's system had all these absentee ballots, which Democrats had embraced because the president had told Republicans not to use them. Did the fact that the chair of the Pennsylvania Republican Party told the president that there was nothing fraudulent about the fact that the Democrats' vote total was continuing to grow, did that stop the president from continuing his efforts to promote claims of voter fraud in Pennsylvania or elsewhere?
It did not, but again, that witness, Mr. Tabbas, was of a similar group of witnesses who, these are not enemies of the president. These are people in his party who supported him. And I think the fact that they were telling him these things would have had, in my view, would have had great weight and great credibility with the jury.
It's kind of the principle that we use in the law of an admission against interest. You know, when your party loyalty leads you to support the president, but instead you're saying nobody's wrong. You think that might give them credibility?
Yeah, I think witnesses of that nature would have had very strong credibility.
I agree. I know some of these folks. Did President Trump try to carry out his fraudulent elector plan in Pennsylvania as well?
Yes.
And how did he do this?
Well, what happened with the elector plan was when they came up with the idea of having these fake electors, there were certain electors who would just not put up with it. Thomas Marino, I think he was from Pennsylvania, is an example of that. And so as a result, and he wasn't the only one in the scheme generally, as a result they had to replace electors. And again, just to keep in mind, all the electors we're talking about here are people who supported Donald Trump. These are people who signed up and said, I want to be an elector for Donald Trump. And these people, when they stepped out, they had to replace them. And part of what's required under the Electoral Count Act is that there are procedures for doing that. And they couldn't follow those procedures because they were replacing people without the consent of the governor, things of that nature. Also in Pennsylvania, I believe it was Pennsylvania, there was a call where, and there's a text of this, where electors were pushing back on this and also wanting to be covered if there was liability and, to be indemnified and things of that nature. And they wanted like statements in their certificates, basically saying you're only going to use this if, you win these lawsuits. And there was a text chain with some of the people who were carrying out this scheme for President Trump. Basically, it ended with these people should be shot because, and that we can't let this snowball like this, otherwise we're going to have to do this in all the other states.
Again, your recollection.
I'm sorry. I don't think he said these people should be shot. I think they said whoever put this slate together should be shot. I think that's what it said.
Well, I think it is one of the reasons the Pennsylvania fake electors didn't get prosecuted was because they pushed back and said, we're not going to sign this unless you include language saying that this will only be used if there are court cases saying that we are the real electors. In your investigation, did you find that the people who were conspiring with the president to push this plan were telling electors one thing and then using their certificates in another way?
Yes, the electors were told that they would only be used in these circumstances, and as other ways of overturning the election fell away, and as President Trump and his co-conspirators became more desperate, they came up with even more obviously illegal ways to try to stay in power, and it eventually devolved to, let's just say that these are the electors, regardless of whether any court has said so, the governor has said so, the people of the state and most have said so, and they didn't go back to electors and say, hey, we're going to use I know we told you we were only going to use this if we won a lawsuit. They just went ahead and used it. And I think, again, even among the fake electors, there would have been witnesses. I'm thinking of one witness in particular in Georgia who I thought would have been very powerful I would never have done this if I thought they were going to use my name to overturn the will of the people just because one person said so.
Okay, okay, I mean, there were other efforts in Pennsylvania. We had the very famous Four Seasons Landscaping Press Conference, which is famous to this day. But there was also a meeting that Pennsylvania State Senator Doug Mastriano hosted in a hotel in Gettysburg, Pennsylvania around Thanksgiving weekend. So, between the certification in Pennsylvania and a presentation of the electors in DC. So even though it was framed as a hearing, Giuliani attended that event and ended up speaking to promote some of these falsehoods about election fraud or wasting votes or whatever, and made it sort of a rally. Donald Trump even called into this event and claimed that he had won Pennsylvania by a lot. Are you familiar with that event?
I do recall that. I think that's in our final report.
I believe so, yes. Did you uncover anything in connection with that event with respect to what they were trying to do with Pennsylvania votes?
Well, I think they were calling them hotel hearings, and it's because they couldn't have hearings actually in the legislature, and so I don't think Pennsylvania was the only state where that happened. Now, there's obviously nothing illegal about having a political rally or having a meeting of people of one political party. Our case was about knowingly false fraud claims.
Right, yeah, it did appear to be more of just some of the kind of performative stuff that we see here where they try to make something out of nothing. Well, I want to thank you for your testimony, for your work, for your integrity, and that of your entire staff, who I know worked extremely hard and with great integrity. And wholly support your request to testify before the American people. I would really like to see that. Americans' tax dollars, including my constituents, have funded your investigation, and I think that they should hear from you directly about what you found and not have your testimony hidden from them. So, thank you.
On another state, on November 20th, Mr. Trump called Republican legislators from Michigan to the White House and urged them to remove the Biden electors and replace them with electors that would elect Trump. They, subsequent to that, made a statement that there was no evidence for that and went back and the electors were certified as the votes had indicated they should be. Subsequent to that, in December, there was an effort to create fake electors. And in fact, on December 14th, when the electoral colleges meet in all the state legislatures, there were 16 fake electors in the basement in Michigan, and 4 of them tried to get into the Capitol to overturn the election. Did you look at that whole phenomena?
We did.
And what was your conclusion? What was the, how would that have played, if at all, in your prosecution?
Well, I think that event you're referring to, and I think we interviewed some of the law enforcement officers who were there that day when they were trying to get in. What they were doing and what the email traffic among co-conspirators showed is they were trying to mimic the procedures that are required by the Electoral Count Act, but they couldn't mimic them. And if I recall, the email traffic on this started with, we have to follow these procedures. And then when it became clear they couldn't follow all the procedures, it was like, well, do the best you can, follow as many as you can. And so I think, if I do recall, certain states, it may have been Michigan, that the electors had to convene in a certain government location. And so as a result, I believe there may have been a state official involved in trying to get them into, if I'm thinking of the right situation, get them in there so again they could mimic the procedures, even though they were not the electors that represented the will of the people, how the vote was actually counted.
Thank you.
I know we're getting close to our hour, we have about 5 minutes left, so I want to end on asking about, and can you just summarize for us the actions that Mr. Trump took with Vice President Pence? What did Donald Trump want Vice President Pence to do to overturn the election results?
Well, ultimately, he wanted him to just hand him the election to say he won. There were different proposals that President Trump and his co-conspirators put to Mike Pence, but in essence, he wanted Mike Pence to impose his own choice about who should be president over the will of the American people who voted in the election.
Was one of those ways that Donald Trump tried to pressure Mr. Pence was to reject the lawful electors' certificates of their votes during the electoral counting process? Was that one of the ways that you recall?
That's correct.
How did Mr. Pence respond back to Mr. Trump's pressure about rejecting the lawful elector certificates?
I think Mike Pence, Vice President Mike Pence, falls into the category that I described before. He did something that was very hard to do. He went against his party. He paid a price for it. But I think, again, someone like that putting country over party, I think he would have been an effective witness. He did not agree to go along with it.
Did you have the opportunity to interview Mr. Pence as part of your investigation?
So, can we stop for 1 sec?
We go off the record. Go off the record, yeah. I'll repeat my question. Did you have the opportunity to interview Mr. Pence as part of your investigation?
I think the answer to that question might involve 6E, and so I'm not going to answer that.
Going back to the response that you just talked about with Mr. Pence's response to President Trump's pressure, is this yet another example of evidence that showed Mr. Trump knew or should have known that what he was saying to the American public was false regarding the election of 2020?
Yes, the vice president was one, and this is alleged in our indictment and our filings, was one of several people saying he was not seeing the outcome determinative fraud that Donald Trump was claiming.
And what would have happened if Vice President Pence would have gone along and refused to count the lawful elector certificates?
Well, thankfully, we don't know, but I would say that he and the other people who stood up and said, I'm not going to do that, may have changed the course of history in terms of our country, of having an election where someone took power in our country who didn't actually win the election. So, as I said, I think it took a lot of courage on his part. He's also someone who, as you all know, when the attack on the Capitol happened, he wouldn't leave. People wanted him to leave. And I think, again, that reflects very well on him.
My last question, I know earlier when you were talking to the majority, there was this discussion of First Amendment issues with Mr. Trump talking about these false claims of the election. Do you remember that discussion?
Yes.
And during our hour, we talked a lot about the knowledge that Mr. Trump had, one, that he had lost the 2020 election, and two, that what he was saying to the American public was false about the 2020 election. Can you help now bring us full circle on how you analyze the First Amendment claims with the knowledge of the fraud that Mr. Trump was putting out to the American public in 2020 and 2021?
Sure. From a legal perspective, this is really quite clear. I think all of us want to make sure people's First Amendment rights are not abridged in a way that they shouldn't be. I think I certainly feel that way. I'm sure everybody in this room feels that way. But there is a very clear carve-out for fraud in our case law. The Supreme Court, I think there's one case, is the Stevens case, talks about that, and there are others. And so when you're committing a fraud, meaning you're not just saying something that's untrue, you're saying it knowing it's untrue or with reckless disregard for the truth, that's not protected by the First Amendment. People commit crimes all the time using words. And when someone commits a fraud, an investment fraud, or someone commits an affinity fraud where you try to gain someone's trust, get them to trust you as a general matter, and then you rip them off, you defraud them. That's all words, but it's not protected by the First Amendment. And in a lot of ways, this case was an affinity fraud. The president had people who had built up trust in him, including people in his own party, and he preyed on that. Some people wouldn't do it, others would. We're lucky that enough wouldn't, that the election was upheld.
Thank you. With that, we'll go off the record at 3:30 p.m. Eastern Time.
I understand, Mr. Smith, you wanted to make some additional comments about the exchange you had regarding your communications with the payday, Marshall Miller.
Yes, thank you. Chairman Jordan didn't ask me this directly, but I just wanted to make sure it was clear on the record. In the series of conversations that I had with Marshall Miller before I accepted the position of special counsel, previous to discussing the idea of working on any of these investigations, he did bring up the idea of me working on another case before that. So that happened, and I ultimately declined to work on that case, and then the other conversations happened after that. So I just wanted to put that on the record.
Okay.
Another case not related to.
Not related, correct.
At that point, were you ready to seek a new opportunity? You know, you'd been in The Hague for some time. Were you looking for an opportunity to come back to the United States?
I really loved my work in The Hague, but for family reasons, if the right opportunity happened, I wasn't desperate to come back, but if the right opportunity happened, I was willing to do that. That's one of the reasons I spoke to Mr. Miller.
Okay. At the end of the last round, I asked you whether you had any communications with the Michigan Attorney General, Dana Nessel, and you said you did not.
Yeah, I don't recall any.
And to the best of your knowledge, you don't believe anyone on your staff was having communications with the Michigan Attorney General's office?
Well, what I thought I said was, I don't recall that. It may be that we got inquiries from them. That may be possible, and it may be we responded to those inquiries. I don't recall sharing information with them or getting information from them.
But to the extent there's an allegation made that your office was coordinating with state attorney general's offices to have prosecutions go on, and different prosecutions happen in the states, would you say that did not happen and that would be false if somebody made that allegation?
We were not trying to coordinate prosecutions with other offices, no.
Okay, and you were not trying to encourage prosecutions at the state level?
No, I don't recall anything like that.
Okay. And so the same can be said with the Attorney General for the state of Wisconsin, Josh Call. Did you have any communications with him?
I've never spoken to Josh Call.
Okay.
Again, we may have got inquiries from their office, and it could be by phone or by a letter. I can't say that didn't happen.
Okay. And to the best of your knowledge, your staff did not have a regular set of communications with the Wisconsin Attorney General's office?
I don't know about regular. If there were requests or if there were people who reached out to us, we may have spoken to them back. I don't recall with much specificity anything about that. We definitely were not trying to coordinate a case with them.
Okay. And can the same be said for the Attorney General for Nevada, Aaron Ford?
I don't even know that name, Aaron Ford. Again, I just want to be clear. This subject you're asking me about interactions with State Attorney General's office, this was not a focus of mine. As the special counsel, I was focused on our cases, our investigations, and our case and what we were doing in court in our investigations. This is the sort of thing that other people in my office would have dealt with, and so I'm probably not your best witness in terms of the level of interaction or witnesses, but I don't recall sharing evidence with those offices.
But if your office did have meaningful coordination with the state attorney generals, you probably would know about it. Is that fair?
Meaningful coordination, I don't know what that term means, but like I said, I'm trying to be as specific as I can, limited by my memory. I don't recall us sharing information or sharing our files with attorney general's offices. I don't recall them giving us their files, things of that nature. Beyond that, the number of times an office may have reached out to us and how we replied to that, I really don't have a recollection of those sort of subjects. I'm trying to be as clear as I can.
Fair enough. How about with outside Democratic lawyers such as Norm Eisen? Did you have any communications with Norm Eisen
No.
during the pendency of your investigation? Do you know if anyone on your staff did?
I don't know of anybody having such a communication, no.
Okay. And how about with Mark Elias? He is a election law attorney for Democrats.
No, I've never met him.
Okay. And to the best of your knowledge, your staff wasn't communicating with Mr. Elias?
To the best of my knowledge, yes.
Same question. A gentlelady by the name of Mary McCord.
Mary McCord, I do know. I didn't know her well, but I knew her from when I had brief interactions with her. She was, I think, at the U.S. Attorney's Office in Washington, D.C., while I was the Chief of Public Integrity. I don't recall having any interactions with her during the pendency of the investigations. At the conclusion of the investigations, one of my lawyers went to work at her project at Georgetown, and I did speak to her about that.
Okay. And what is her project at Georgetown?
It's some sort of clinic at Georgetown University. As I sit here right now, I don't know the specifics.
But you didn't have any discussions with her about the facts of the case?
No, my recollection, that may have been the first time her and I had ever actually had a conversation, her and I talking to each other.
Okay.
But we definitely didn't talk about the case while it was being prosecuted and investigated.
We've discussed, both sides, I think, have, raised the fact that President Trump was, he's being prosecuted by a lot of different tribunals at the same time. I mean, he had the District Attorney of New York, he had a civil case with the Attorney General for the state of New York. He had two federal cases. And, I had asked you about how you managed the calendar and the calendar with President Trump. I mean, there were times when he was required to be in New York 3 or 4 days of the week, and then he had to be in Florida for, I think we discussed at the end of our last round, for a pretrial motion hearing. And it just seems that at every instance when President Trump and his lawyers requested a little bit of a delay because of the cases they're defending, your office was not willing to indulge that request.
It is correct that we were not willing to indulge delays that we thought were inappropriate. I will add, and this is in the litigation, there were numerous instances where judges chided counsel for President Trump for trying to delay things. I'm thinking, as I'm saying it now, I'm thinking specifically of the executive privilege litigation that we had. This is referenced in our final report of him attempting to delay things. And so we agreed to dates that we thought were appropriate. All of that, as far as I'm concerned, was very public and transparent. What the dates were and the arguments to the judges about those dates were clear, and I thought they were fair and reasonable.
Even against the backdrop that he was being tried by the District Attorney of New York, and even against the backdrop that he was involved in a high stakes proceeding with the New York Attorney General?
Yes.
For example, at the time you proposed the DC schedule, you were also aware that Georgia prosecutors had proposed motions hearings, essentially during the same time period. If President Trump's lawyers had requested a delay for that, would you have indulged that? Or did you indulge that if they did ask for it?
I don't recall if they asked for a delay, and to consider whether I would indulge that, I would have to be back in that moment and look at the facts as they existed at that time. I don't recall that as I sit here now.
President Trump complained that he was treated unfairly with respect to access to the classified information that was at the heart of the Florida case, that he wasn't able to review the materials at the heart of the trial because of restrictions imposed by the government that required him to only review the materials, on your turf. Is that something that your office did intentionally?
I think this may be one of those subjects that may be in the final report in Florida, so I don't think I can get into that.
Okay.
I'm not sure it is, but it may be, and I just want to exercise
Okay.
caution.
So I have some questions along this line. If that's going to be your answer, I understand that. So I'll just,
If you can point to a public filing where this has been discussed, I'm happy to comment on the subject in the public filing, because I think my understanding is it's pretty clear that I'm allowed to discuss public filings, and so if there is a public filing you're aware of, I'm happy to
yeah,
address that to the extent I can recall it.
okay.
I want to answer your questions as much as I can, I just don't want to run afoul
Right.
of this injunction.
The heart of the question is, he had a skiff at Mar-a-Lago that was decommissioned when he was no longer president, but during the pendency of the case, it would have been relatively easy for him to get that skiff at Mar-a-Lago back up and running. And he indicates that your office blocked that and, required him to only look at the classified documents, only talk with his attorneys about the content of the classified documents in a DOJ scheme.
So-
And that puts us, a remarkable burden on him, especially given all the other cases that he was defending.
Okay, so if there is a public filing about this, I am happy to discuss this with you. I just want to make sure that there's a public filing, so I'm not running afoul of anything in the injunction.
See if we can get it quickly.
Sure,
If not,
of course.
maybe we'll move on.
Yeah, and then we can come back.
Come back to it. After the immunity determination at the Supreme Court was decided in July of 2024, you filed a remarkably long brief in September of 2024. I think it was like 165 pages, and the brief was very, very unusual in terms of length and content. What can you tell us about your decision to proceed with that type of meaty brief? It's almost as if you were writing your, special counsel report in that brief.
Sure. As an initial matter, I think the vast amount of the factual material in that brief was not new. It was just put in there to address the issues at hand. The context of this is we received this immunity decision. The immunity decision affected not only the indictment, it affected the evidence we could use at trial. And so for there to be a litigation of this, the defense would have to know the evidence at trial. We would have to say, this is the indictment, and here's the other evidence that we're going to use at trial, in summary at least. We all understood, at least certainly I did, that this case was going to go up to the Supreme Court at least one more time for an interpretation of a lot of the questions that the Supreme Court left open, which we addressed in the final report. Our goal was to have that be one time and to have the evidence and the indictment get rulings from the court. If the defense didn't like them, they would get to appeal them. That would go up to the Supreme Court. We get a final understanding, and then we'd be back before the court to try the case. And so to do that in one trip as opposed to multiple trips, and multiple trips could mean years in terms of how long it would take to try a case, that required us to go first, to in essence put this there. And I said this earlier in the day to you, one of the challenges in this case is we had, in my view, a very strong case with a lot of evidence, and trying to condense that into a brief at that stage where we were not going to be precluded from offering things that we thought were important, that could possibly be relevant to any of the immunity issues, but also have a fulsome brief. That's what we filed. It was my judgment that that was what was necessary, and I think, again, if you look at that brief, the vast majority of factual information in that brief had been in the public or something close to it in the past.
Required you to go first, or you chose to go first? Because the normal case is my understanding, you file a superseding indictment, defense is going to make some motion, they're going to have some reaction to that, and then you would do a brief. But you flipped it.
Well, because in this particular case, we had the opinion that caused us to supersede the indictment. The court said not only what's in the indictment, but the evidence too. And there had never been a point at that point where we had put on the table, here's all the evidence that might be related to immunity. And so we needed to do that. Otherwise, the defense couldn't respond to it. What would have happened would be we file a brief of our trial evidence, or of our indictment. They say no or not. Then that goes all the way up to the Supreme Court. Then we come back from the Supreme Court. Now we're going to do a second year.
Doesn't change the question, Mr. Smith.
I'm
Was it
sorry.
required, or did you choose it?
I believe that was the most appropriate way to go forward, yes.
It's not my question. Was it required, or did you choose to go that route?
Oh, I chose it.
Okay.
But I'm sorry that I wanted to explain the reasons why I chose it.
And did you have to file a motion with the judge for leave to offer that type of filing?
We had a status conference with the judge shortly after the return of the superseding indictment, and we proposed, my choice, that sequence, but we left it to the judge to decide the timing of that sequence, of when our brief would be due.
And what was the timing of that sequence, to the extent you can recall?
I'm happy to venture a guess, but there's a public record of this. I want to say it was 2 to 3 weeks we were given to write our brief, but trust the record instead of my memory on that.
And so the brief was filed right at the beginning of October, I think, or the end of September?
Whatever the record shows.
And the election was just weeks away, correct?
The election was November 3rd?
Yes.
Yep.
Did you have any communications amongst your staff that this presented potentially a problem with the Justice Department's election year sensitivities guidelines?
So when we got the immunity decision, we had a series of decisions to make. The first was to look at our evidence and see, do we still have a case here? Do we still have admissible evidence that would allow us to proceed to trial? So that's what we did first. Once we determined that we did have that evidence, the next thing we determined is, do we need to supersede the indictment? And because there was evidence before the grand jury that the Supreme Court had clearly said was immune, we determined that we needed to supersede the indictment. And I'm sorry I'm being long, but I think the context will help. Once we determined that, we had to make sure that our conduct in going forward with an indictment and everything after complied with the election year sensitivities policy. And to do that, we consulted with public integrity on drafts of the indictment, on our plan forward, and as we set forth in the final report, Ping concurred that we had complied with that policy. And I would just add that policy does not stop prosecutors from trying their cases in court.
Okay. Did you or anyone in your office discuss the potential political or electoral impact of publicly filing that amount of information, just with the election a month out?
My focus was on making sure we complied with the election year sensitivities policy, which is the way the department addresses those issues.
Okay. And so, the whole purpose behind the policy is not to interfere with elections, right?
Correct.
And so, the way the policy is written, I guess, is that as long as you have filed your case and as long as you're already in court, then there's no limitations on the types of court filings you can make. Is that right?
Well, I will say, and as you know, I was the chief of public integrity. Historically, I don't recall any cases where it ever applied to anything. It was really about investigative stage steps, doing a search warrant or taking investigative steps before an election. But this is one of those issues where this is why you consult with public integrity, because they're now the keepers of that policy.
Right.
And so we consulted with them about the path we took, and they agreed that what we ended up doing did comply with the rules.
I mean, after you left public integrity, you know, there was a February, the 2020 memo from Attorney General Barr and Attorney General Garland, in effect re-upped Barr's memo with his own election sensitivities
Yeah.
memo. I think he incorporated it by reference, in
Yeah.
fact. You know, and this is against the backdrop that a lot of what happened during the 2016 election caused a lot of concern that what happened at FBI, what happened with, you know, both the Crossfire Hurricane investigation and the mid-year exam investigation, you know, may have affected the outcome of the 2016 election, correct?
I'm not saying that's wrong. I'm not sure I followed that closely.
Okay. I mean, you're aware of the concerns of the Justice Department, you know, in the fallout of the Crossfire Hurricane investigation.
I don't think the election year sensitivities policy was born out of that. I think it's existed for a long time and in kind of the same format for a long time. And I know the last person to sort of restate it was Attorney General Garland, who I think did it shortly before I was appointed, if my recollection is correct.
But he incorporated by reference, you know, Attorney General Barr's memo from 2020. And Attorney General Barr, you know, his memo was in the fallout, you know, it was in the wake of everything that happened with the Steele dossier, what happened with, you know, Crossfire Hurricane, and so forth. And so the question is, your 165-page brief, a month out from the election, it's, you know, it seems from an outsider's perspective that runs the risk of, you know, impacting the outcome of the election.
Yeah, we certainly were not in any way intending to affect the outcome of the election. And to make sure we complied with the policy, we met with public integrity to make sure we were doing that. They agreed, and they're the ones who enforced that policy. And so I felt comfortable taking the course that we did going forward.
Did your office ever consider some of the things that happened to President Trump, you know, in the 2016 election with the Steele dossier, with, you know, using the Steele dossier to get, you know, FISA warrants? Did you ever discuss any of that as you know, background that we need to be careful here with President Trump, that we don't you know, repeat some of the things the Justice Department went afoul of in 2016?
I don't recall ever discussing the Steele dossier or anything like that with my staff. I don't recall that.
And, you know, I know Justice Department officials often like to say that, hey, everyone at the Justice Department is nonpartisan, apolitical, they check their politics at the door. And I think you would say that is the case with everybody on your team, correct?
I would say that has been my experience in the Justice Department through both Democratic and Republican administrations. I've worked in the department through both, and that has been my experience.
And, you know, we learned in the fallout of the 2016, the events of the 2016 timeframe, that, you know, there's Peter Strzok and Lisa Page, and, you know, I think we can all agree they were not apolitical and nonpartisan. They were, you know, very clearly, you know, as their text message traffic, you know, bears out, they were, you know, very interested in preventing President Trump from becoming president. Is that something that you were aware of?
I was aware factually of that,
Right.
yes.
And can you agree that, you know, as the text message traffic bears out, those two officials were not, you know, nonpartisan and apolitical?
Well, I certainly agreed with Director Mueller's choice to move them off the team once he discovered those, absolutely.
And did you ever have any discussions with your senior management to make sure that your team wasn't infected by any of those types of issues?
Yes, I did.
Okay. And can you tell us about that?
So I made it clear from the day that I began at the special counsel's office, this was going to be a nonpartisan investigation. This was not, the politics would play no role in it. I think everybody in my office agreed to that. I can tell you of one incident where we were reviewing the email chains of agents who might be witnesses in the case for Jiglio review. And we needed them to give us all their emails. An FBI agent who was working on the case took that direction and actually provided us with his private emails with his family. We didn't ask for that, but he gave us his private emails. In one of those emails, and I can't remember if I saw this or my deputies saw this, he was having a dispute with family members where it was about January 6th. Once I saw that or heard about that, I decided he could no longer work on this investigation. And I think that was consistent with how I ran the office. And I want to also be clear, I never saw that agent do anything that I considered partisan. But just to make 100% clear to my staff, and this is an agent who volunteered this beyond what was required. I wanted to make it very clear that anything like that was not going to be part of our investigation.
The 165-page brief that you filed at the beginning of October, was there a consideration of maybe filing it under seal, at least until the election was over?
Well,
Obviously, you have to go to the court and all parties would have to agree, but certainly if all parties agreed, the judge would be amenable.
I feel like this came up in the status conference that we had. I can't recall. What I can recall, though, now that you're reminding me, is there was an issue, and this is referenced in our final report, where we filed our brief. They were given time to file their brief. They wanted more time, which would put their brief after the election. We had our exhibits, which were really the evidence, that we were citing. That evidence, they made a motion that evidence, the key facts, should be filed under seal. And before filing their motion, usually the practice is to ask opposing counsel what's your position about this. But they filed their motion before they could get our position. And so we contacted the court and we said that we had no objection to that evidence being filed under seal if the court agreed. Now, the court ultimately did not agree. And so this is referenced in a footnote in our report. I think that is pretty direct evidence that we were not seeking to put the maximum amount of facts in the public record, that we were happy to have that be under seal, and even after the election, if that's what the court agreed.
Okay, but you could have sought permission to file that big brief under seal, right?
I suppose we could have, and again, this is where my memory is escaping me. I feel like this issue was possibly discussed with the court, and I think the record of what any briefing on this or what the court said will be better than my memory about this.
Okay. Did you think it was important that evidence be in the public realm before the election, so people could make up their mind about who they were going to vote for?
No, I did not see it as our role to provide evidence for people to make their voting decisions on. Yeah, if I could, the final report on page 107, footnote 258. On the 17th of October, Mr. Trump filed a motion to delay public disclosure of our appendix to the brief, meaning the actual evidence.
Sorry, say that page again?
Yeah, sure. It's 107. I'll let you get to it. 107, footnote 258. They filed a motion to delay the appendix, meaning the evidence, until after he filed his own appendix, which would have been November 14th, well after the election.
Yeah.
So that both appendixes will be released simultaneously after the election. He filed that motion before obtaining our position, so we emailed the court's chambers, copying defense, informing the court that we did not object to that procedure, meaning we did not object to our evidence being, in essence, embargoed from the public until after the election. So I think that's pretty strong evidence that we were not trying to have an effect on the
Notwithstanding the
election.
fact that it's a 165-page brief that you sent.
It was.
And that's, in my understanding, first of all, you choose to do it, 165 pages. I think it's 4 times the size of the normal briefs that are supposed to happen with these type of motions. And I believe the judge said this was not typical. Is that right?
Yes, but
Judge Juckin said it was not typical.
she used a word like that, but I would just say when you say these type of motions, I think filing a brief after an immunity decision is not a common issue, and having to have a new evidentiary issue added to the mix in addition to the immunity issue, I don't think this is.
Is there any new evidence in the 165-page brief?
I'm sure there was, but as I said, my recollection is the majority of the evidence was already public. The brief emphasized how we could prove our case using evidence of his role as a candidate, as opposed to evidence that might otherwise be precluded by the official act. So, for example, a thing in the brief would be that at least 2 of the White House staff members who would have been witnesses, that they also were also working on the campaign. And so, not a particularly important fact in the world, but important for our particular brief. So there were facts like that and others that were new that were in the brief.
I just want to summarize those, but you choose to do this, not required. You go out of the normal order, so that's different. It's 4 times the size of the brief that the court wants you to file, 45 pages, and you do 165 pages. The judge herself said it was atypical. You have introduced new evidence that is public, and you do this 32 days before the election. And public integrity said just fine.
They agreed that our course was consistent and in compliance with the election year
Same
sensitivity
public
policy.
integrity said that all the toll analysis was just fine. Okay. Thanks.
Were you, during the pendency of the investigation, were you aware that at the Capitol on January 6th, FBI had confidential human sources?
I'm sure I probably was. I think there was public reporting on that.
But did you know that also as part of your work?
I'm sure, yeah.
Okay. And do you know how many there were?
As I sit here now, I can't recall. I know there was an Office of Inspector General report about this, that there were no undercover officers there, as had been reported, but there were informants there, some who had gone on their own.
And did your office oppose President Trump's discovery request for information relating to the confidential human sources?
I would have to look at our filings on that.
Okay. As we understand it, your office did oppose that and said any such information is not relevant to the charged conduct or as a valid defense in the case. And so consequently, you were not in favor of that. Does that refresh your recollection at all?
I'm not disputing what you're saying. I haven't read the filing. What I recall is there was also a database of evidence from January 6th that the DC U.S. Attorney's Office would give access to defendants who were involved in those cases, and we gave President Trump and his attorneys access to that. I'm not sure they ever accessed it, but
Okay.
I do recall that, and there may have been a filing like you talked about.
Okay. Let me make this an exhibit. The next exhibit will be number 12, and this is a letter from Stanley Woodward, Stan Brabs, about the interactions they had with Jay Bratt on August 24th, 2022, before you were appointed special counsel. You familiar with the allegations that Mr. Woodward raised about Mr. Bratt?
Yes.
I'm going to refer you to 2 paragraphs in this letter. The first paragraph is the last one on page 1, and the second paragraph on page 2. And please, familiarize yourself with this. But I just wanted to flag in advance that I'm going to zero your attention in on those two paragraphs.
Yes.
Okay. This letter to Judge Boasberg from Brandon Woodward states that again, this is the last paragraph on page 1. Despite the purported purpose of the meeting, it began with Department Attorney Jay Bratt referencing a folder of materials in highlighting Mr. Woodward's professional background. Specifically, Mr. Bratt remarked that he was aware of the fact that Mr. Woodward had been recommended for a presidential nomination to the Superior Court of the District of Columbia. Mr. Bratt also advised that the government's case against Mr. Nuada was strong, referencing his belief that one way or the other, Mr. Nuada would be giving up a lifestyle of private planes and private golf courses, and that it would behoove him, Mr. Nuada, to cooperate in the government's investigation. It was inappropriate for Mr. Bratt to mention the fact that Mr. Woodward had been recommended for a presidential nomination to the Superior Court of the District of Columbia. The only rational inference to be drawn from this reference, combined with the assertion that the government's case against Mr. Nuada was strong and that Mr. Woodward was not a so-called Trump attorney who would do the right thing, is that somehow Mr. Woodward's potential nomination to the Superior Court would be implicated by Mr. Nuada's decision not to cooperate in the government's investigation. Indeed, to the best of Mr. Woodward's recollection, Mr. Bratt concluded his observations with words to the effect of, "I wouldn't want you to do anything to mess that up," referring to the potential nomination. It is, of course, noteworthy that the statements giving rise to this inference were coming from a senior official with the Justice Department. I asked you whether you had a recollection of these events, and you said you did.
I do.
Do you think it was inappropriate for Mr. Bratt to make a suggestion to Mr. Woodward that, he ought to cooperate, and if he does cooperate, if Mr. Nuada chooses to cooperate, the implication was that his application to be, a judge will be looked on more favorably by the Democrats at the Justice Department?
I don't think that happened, but I'm happy to share with you my perspective on this.
Okay.
So,
And let me just say
Yeah.
one thing, if I may.
Sure.
These judges for the District of Columbia, the Justice Department weighs in on it. Is that not the case? The White House counsel's office, works to come up with the names they're gonna submit for a nomination. But the way the procedure works is the Justice Department, does the vetting.
I don't think I knew that until this issue came
Okay.
up, which I'm happy
Yeah.
to explain. So, with the District of Columbia particularly.
Right. Okay.
Very short time before this, matter of days, this is right around the time we had given notice that we intended to move forward with an indictment in the classified documents case of both Mr. Trump, President Trump, and Mr. Nuada. As is my practice in cases like this, we gave Mr. Trump's attorneys an opportunity to come in and give me arguments as to why not to indict the case. And in the course of my life, I've heard those arguments and sometimes not move forward on cases. In this particular situation, because my decision would ultimately be reviewed by the Attorney General, who could countermand it, that meeting was with me and Bradley Weisheimer, who was in the Justice Department. Mr. Trump's attorneys were there. It was Jim Trusty, Lindsay Halligan, and there was a third attorney who I can't remember, but I'm sure there's a record of who that was. They gave reasons why they thought the case shouldn't be indicted. And for the first time, this is my recollection, they raised this issue that somehow Jay Bratt had threatened Stanley Woodward. Now, I was surprised by this because we had interacted, I hadn't, but my counsel had interacted with Mr. Woodward numerous times over my time as special counsel. He not only represented Walt Nuada, he represented other witnesses on on the classified documents case. He represented, I believe, multiple people in the elections case. And so all this time passing, this has never been raised before. I went back to my office. That meeting was at the main Justice Building. I went back to my office, and very shortly afterwards, I informed my deputy, J.P. Cooney, about this and Ray Hulser about this. They contacted Mr. Woodard to ask him about this. I believe there are notes about that, notes of either J.P. Cooney or Ray Hulser. I'm not sure. My recollection of that, and again, they would remember this better, is that Mr. Woodard expressed surprise that anybody had raised this, and he said something to the effect of, well, I know how to make a complaint if I want to. Take that for what you will. That was the initial response.
What day was this?
Yeah,
What time frame, generally?
like early June, so like before the meeting with the attorneys was in the days before we ultimately went forward with the case. I'm not sure how late this letter was after this when I came back to the office. I tasked Mr. Cooney and Mr. Hulser to speak to the people who were present for this meeting. None of them believed that Jay Bratt would threaten Mr. Woodard. It didn't make a lot of sense that a career prosecutor would, in the first meeting with the counsel they never met, threaten them. One of the things they asked about was this issue about the judicial nominating thing. And Mr. Bratt explained that he had not met Mr. Woodard before and not had a case with him, so he had looked him up. And when you pull up information about Mr. Woodard at the time, there's a page that comes up, and we attached this in one of our motions. It says Stanley Woodard Judicial Nominating Commission. That page makes it look like he is on, at least if you look at it quickly, on the Judicial Nominating Commission, not that he has a candidacy. Mr. Bratt explained to us that he was under the impression that Mr. Woodard was on the commission and raised it as a sort of like icebreaker, like, I understand you're on this commission. Now, whether Mr. Woodard misunderstood that or some other reason, here he says he drew an inference that he was making some sort of threat. That didn't make a lot of sense to me, given all the interactions he'd had with our office. I think Mr. Woodard later started talking about a campaign against him, but he had meetings with people in my office repeatedly in positive ways. And finally, I also thought it was noteworthy that Mr. Woodard didn't bring up this issue for many months. And then the first time that he brings it up in this letter, he's doing it to seek strategic advantage, because he didn't report it to OPR, didn't want it reported to OPR, never asked that. And now he wants it not only reported to OPR, but he actually wants to delay the indictment of the case until that's concluded. I will say that when we confronted, I say we, my deputy spoke to Mr. Bratt about this, he self-reported it to OPR, which is pretty standard in these sort of situations. And so, and I would also just say, this was some time ago, we did a filing on this that I believe is public, and that filing will reflect my best recollection of these things. And so I did not credit these allegations, but we made sure they were referred to OPR.
But, you know, a counterpoint to that, if Woodward has a bunch of cases before your office and he's, you know, representing a bunch of people, I mean, he may have felt threatened, but he also may have felt that it was in his strategic advantage to just try to forget about it because he doesn't want to make an enemy of Jay Bratt. I mean, isn't that a fair counterpoint?
I don't think so, based on the number of interactions we'd had with him, and also the fact that he didn't even bring it up. Someone else brought it up, and when he was, again, I was told when he was confronted with it, he was surprised someone brought it up, made a reference of, I know how to make a complaint if I need to. That was my recollection. And then when he did make the complaint, he didn't just say, I think this should be referred to OPR. He said, and it may be in this letter, That, yes, I think that this, let me make sure I get the language correct. Yes. We respectfully suggest that this matter be referred to the department's Office of Professional Responsibility for a thorough investigation, and that any indictment arising from this investigation not lie until such an assessment is reached, knowing, as we do, that an OPR investigation can take many, many months. So that's my take on what happened. And I think our office responded appropriately to this. I don't credit it, but at the same time, we referred it to OPR so they could look into it.
So if it did happen the way Mr. Woodward or Mr. Brand say it did, you would have an issue with that then? Is that fair?
I have no evidence that any of my prosecutors threatened defense attorneys. If prosecutors under my supervision threatened defense attorneys, they wouldn't be working with me any longer.
Okay. What we're here is talking about essentially a veiled threat that he believes Brat was mentioning this off the cuff to try to get him to play ball with NARA's cooperation. So if that had happened, you certainly wouldn't condone that, would you?
I would not condone anyone threatening a defense attorney, but I also say that if you've practiced law and practiced criminal law, I mean, that's just not something that would work. I mean, that's not something that I've seen an experienced prosecutor do, and to do it in front of several other prosecutors. It just, in addition to, for all the reasons I said I didn't credit it, I also think it just doesn't make a lot of sense. But to your point, if, unlike this situation, a lawyer who worked under me threatened a defense attorney, yes, that would be inappropriate.
During the last hour, turning the page to a different topic, you said that you had not yet considered a sentencing recommendation had President Trump been found guilty in either one of the cases. I mean, do you think that you would have recommended a jail sentence, prison sentence, if he was convicted?
I'm not going to speculate that on that, because that would require a very detailed analysis of the sentencing guidelines factors, of what he was convicted of any mitigating factors. That's not something you do off the cuff, whether someone should be incarcerated or not, or how long. That's not something I would do without significant analysis.
And had your office undertaken any type of analysis on that front?
In terms of a thorough analysis, I don't recall anything like that. I'm sure that we knew how much the sentence could be in each individual thing, but I certainly had not turned to thinking about what sentences should be. As a rule, I don't do that until there's a conviction in a case.
Okay, but what would have the sentence have been for the charges that you indicted for?
I'm not going to speculate. I mean, if we sat down and went over the sentencing guidelines, we could talk about what that would be, but I have not done that analysis, and I haven't thought or looked at or thought about that issue.
Would that analysis have yielded some jail time, or recommendation for some jail time?
Again, I'm not going to speculate on that, because as I mentioned earlier, you only get to that if you try your case and you prove it beyond a reasonable doubt. We did not do that in this case. There was no trial, and we didn't do that.
Do you have any members here? Just, we have a couple minutes left in our round, so I was just making sure
Sure.
we didn't, if we had some members here that needed to ask some questions, we'll make sure we factor that in. The individual who worked for Mark Meadows by the name of Cassidy Hutchison was she was a star witness for the January 6th committee proceedings, and she made some real outlandish claims that, for example, one of them was that President Trump tried to take control of the wheel of the Suburban that he was being driven in. Is that an allegation that you're familiar with?
The circumstances regarding President Trump getting in the Secret Service vehicle after the alleged speech, yes, I am.
Okay, and what did your offices, did you evaluate that claim?
We did.
Okay, and what was your determination?
Ms. Hutchinson, regarding that particular claim, was a second or even third-hand witness. She had heard other people talk about that.
Okay.
And so we went to, we interviewed, I think, the people she talked to, and then we also interviewed, my recollection's correct, officers who were there, and including the officer who was in the car.
Right.
That officer, if my recollection is correct, and I want to make sure I'm right about this, said that President Trump was very angry and wanted to go to the Capitol, but the version of events that he explained was not the same as what Cassidy Hutchinson said she heard from somebody secondhand. That's
Okay.
correct.
On the morning of January 6th, White House officials told President Trump that people at the rally had weapons. This is the President Trump's speech on the ellipse, and that they did not want to go through magnetometers because they didn't want their weapons confiscated. Cassidy Hutchinson initially testified that no one informed President Trump before or during the rally that people did not want to pass through the magnetometers because they didn't want their weapons confiscated. During a subsequent interview, she sort of changed her tune a little bit and claimed that Deputy Chief of Staff for Operations Tony Ornato and other officials did inform President Trump that people standing outside the rally area did not want to go through the magnetometers because they did not want their weapons confiscated. Other witnesses contradicted this claim pretty thoroughly. Did your office evaluate that claim?
Yes, and I think I discussed this earlier. We interviewed a number of people, and I think on this particular claim, there were a number of different perspectives about that. I believe it was Ms. Hutchinson, Mr. Ornato, I believe Mr. Meadows we spoke to about this. As I sit here right now, I cannot recall what each of them said. I know each of them were seeing it from a different perspective, and they were with Mr. Trump at slightly different times. So as I sit here now, I can't recall, but I do recall that there were different perspectives on that question, yes.
Did your office consider whether you would call Cassidy Hutchinson as a witness at trial?
We didn't make a final determination about any witnesses, but my recollection as I sit here now is that one of the issues, there were two issues really. One, there were so many witnesses that we could have called, and there was a need if we wanted to present a case in a digestible format where there wasn't just weeks and weeks and weeks of testimony, we had to slim it down. And my recollection with Ms. Hutchinson that at least one of the issues was a number of the things that she gave evidence on were secondhand hearsay, were things that she'd heard from other people. And as a result, that testimony may or may not be admissible, and it certainly wouldn't be as powerful as firsthand testimony. So I don't recall if we made a final determination about that, but I remember in my mind that being a consideration that some of the things that she could offer testimony on would be hearsay, and we wanted to condense the case as much as possible for a clear presentation.
Did you reach a determination about whether her testimony was reliable?
I don't recall reaching any sort of conclusion like that because we were, again, far away from trial. We hadn't made final determinations.
If you were a defense attorney and you were given the assignment of cross-examining Ms. Hutchinson, would you consider that assignment a very challenging one?
Well, if I were a defense attorney and Ms. Hutchinson were a witness, the first thing I would do is seek to preclude some of her testimony because it was hearsay. And I don't have the full range of her testimony in front of me right now, but I do remember that that was a decent part of it. And so That would have been my first gambit if I was a defense attorney.
There was other evidence where she said she wrote a note, whether it was to Mr. Meadows or Mr. Trump.
Yep.
But it wasn't her handwriting. Eric Hirschman wrote the note.
Yes, there was a conflict between them on that issue, that's correct.
You know, a witness says, I wrote a note, that's my handwriting. I mean, that's a pretty serious, potentially false statement, correct?
Well, like I said, we didn't make any final determinations about who we were going to call or not, but there were instances, you cited a couple where we had evidence, we had different perspectives about an issue, we had secondhand hearsay about an issue, or two witnesses not remembering something the same way. So those are all accurate.
Was your office, let me restate and just say that numerous witnesses that were ensnared by the investigation complained that they were debanked. Does the term debank mean something to you?
No.
Where they were basically told by their bank that they needed to go find a different bank. And there's a long list of, Trump allied, officials that were subpoenaed for the grand jury that were, brought into your investigation that claimed they had been debanked, and that Capital One told them to go find a different bank, and numerous other banks. Do you know anything about that?
No, I do not.
Okay, so your office didn't have any communications with banks urging a bank to separate from any of their customers?
I have no knowledge of that.
Are you aware of that allegation, or is this the first you're hearing of it?
I'm trying to think. I didn't know what the term meant when you first said it, so, I mean, in the scheme of the world, have I heard of the word debanking? Maybe, but if you'd asked me to define it when you first said it, I don't think I could have.
Okay. But have you, so you haven't heard that allegation that some of the folks in President Trump's inner circle have complained that they, were kicked out of their bank?
Complain to the special counsel's office?
No, they've complained publicly that the fallout from this investigation has made their life very difficult, that they have been, been forced to get a new bank because, Capital One won't support them.
I don't recall that, but I'm not denying that people may have said that. I'm not
Okay.
aware of it.
This is sort of the first you're hearing of it?
As far as I can recollect, yes. Well, actually, sir, can I just add one thing there?
Of course.
When you were interacting with my counsel and talking about the issues you might ask about, you said debanking was one of the issues. That was the first I'd ever heard about it.
Oh, okay. All right. Very well. Looks like our hour's mostly up here, so I'll stop there. Can we go off the record?
In the last hour with the minority, Mr. Smith, we asked you about folks that were interviewed during the course of your January 6th investigation. I think we talked about Mr. Giuliani, we mentioned Mr. Meadows, we mentioned Vice President Pence. An individual that I failed to ask about was whether you interviewed Director Kash Patel as part of your investigation with the Special Counsel's office.
I can't get into that because of the Judge Cannon's injunction.
Okay. Did Director Patel testify before the grand jury as part of your investigation?
Same answer.
Can you mind saying that just for the record, to make it the record?
I cannot answer that question due to Judge Cannon's injunction.
And did Director Patel assert his right against self-incrimination as part of your investigation?
Can't answer that question.
In general, just using your years of experience as a prosecutor, are you aware of any prohibitions that would prevent Mr. Patel or Director Patel from disclosing his own testimony if he did testify with the Special Counsel's office?
Just as a general matter, not specific to anything with this case, my understanding is the witnesses can disclose their own testimony.
Thank you. Mr. Raskin?
Mr. Smith, do you believe that the Supreme Court's decision on executive immunity constitutes an exoneration of President Trump's conduct in the months and weeks leading up to January 6th and then January 6th.
No.
Would you just explain that for us, why you don't see that as an exoneration for what he did?
Sure. I understand the Supreme Court decision. If I just go back for a second, this was an issue we litigated in the district court. The district court agreed with us. We litigated it in the Court of Appeals. The Court of Appeals agreed with us. We litigated it in the Supreme Court. The Supreme Court majority did not agree with us. They took a view of executive power that was more expansive than what we argued. I disagreed with it for the reasons we set forth in our brief and the reasons stated by the dissent in the case, Justice Sotomayor. But it is the law of the land. And what my office sought to do in responding to that was to follow the law and see, do we still have a case? And I think the evidence that we had after that decision remained powerful. I talked earlier today about state officials who put allegiance to the country before party. Those officials from Arizona, Wisconsin, Michigan, Pennsylvania, all those. I'm sorry.
Georgia.
All those witnesses, right? All those witnesses would still be available to us. The heart of our case would still be available to us, and I think it's important to know that. Well, our view was that he abused his authority in the Justice Department to effect as one way to effectuate this scheme. This was about him as a candidate trying to say he won an election he didn't win, and so having to frame this in that manner, obviously it limited some of the evidence. That's why we had to supersede the indictment. But I don't think it was an exoneration because I still believed that there was substantial evidence that would allow us to prove the case beyond a reasonable doubt.
Someone can be guilty of a crime in a factual sense, but still be immunized from prosecution, right?
Well, I mean, that's getting sort of like theoretical or metaphysical. I mean, if the court says that that's not a crime, then it's not a crime. But in our case, our view was that that ruling excised a certain portion of our proof, but all the charges we brought, we felt were still valid. We felt we still had a lot of evidence to support those charges.
Right. Did you have any questions? But I wonder if you would answer a question based on your experience as a war crimes prosecutor. And I don't know whether over the course of your long and distinguished career you've come to articulate a difference between ordinary crimes, run-of-the-mill crimes, and crimes that have some kind of world historical significance. Perhaps so, perhaps not. But I wonder if you do put war crimes, for example, in a different category from, say, for example, robberies that you've prosecuted, how you would think about classifying the crimes that you had investigated and were prepared to prosecute related to January 6th and the attempt to overthrow a presidential election.
So I think as a prosecutor, how you go about investigating those cases and make a decision to prosecute those cases, in my view, the principles in the robbery case or in my early career domestic violence case, those are the exact same principles you'd use in the most terrible war crimes case or in the work I had as special counsel. You follow the facts and the law. Nobody's above the law. You treat everybody the same. Applying those principles in more complex cases requires experience, and it's one of the reasons I felt I was qualified to do this job. But the principles, I think, remain the same. In my view, my personal view, is that the difference is the harm. Domestic violence case is awful. It should be prosecuted to the full extent of the law, but generally there's one victim. War crimes cases that I've worked on can affect an entire country, an entire culture. I think, and this isn't just me, The Court of Appeals, in this case, when we litigated, it said that if the things we alleged were proven, it would amount to attack on the structure of our democracy. Those aren't my words, those are the court's words. And so whether a case is of that import or of less, I think you go about it the same way, but obviously the consequences for our country are quite different.
Have you made any statements, or are you willing to make any statements on the firing and removal of the Department of Justice prosecutors who worked on January 6th, on people at the FBI who were involved in the FBI investigation, or on the president's mass summary pardon of 1,600 January 6th insurrectionists and other people involved?
Yeah. I think what has happened to career prosecutors and career FBI agents is awful. It's contrary to the rule of law. It's contrary to who I think we are as a country. One of the agents on our case, he served his country overseas multiple times, war zones. Family of dedicated public servants. Wife's family, dedicated public servants. He got fired for doing his job 2 weeks after his wife died. I went to the funeral. I saw his family. I saw a church full of public servants. No reason a person like that should have to go through that. And I'm getting emotional. I'm sorry about that. But I just think that's wrong.
Well, thank you for your service to America and to the Department of Justice and the people.
Following up on that a little bit, if individuals are fired or lose their jobs simply for taking part of an investigation into someone who is an authority figure or in a high position of government, how does that impact our democracy?
Well, if you take the position that you cannot work in the federal government unless you have a political allegiance to the president, I think there are many harms to that. Our country tried that in the past. It's called the patronage system. And what we learned in our history is, and this would be, if it's a Democrat or Republican, would not matter. But what we learned is that those systems are rife with not only corruption, but with incompetence. Because the people who have these jobs, they didn't get them because of merit, because they dedicated their career to learning national security law, to learning how to properly investigate a case. They got their jobs because they're loyal to a particular person. That's not fair, but it also makes for people who really don't know how to do the work. And so I think that's a danger to the country. It saddens and angers me in the short term, but I think there are great costs to us long term if that's the direction we go in.
I'm going to pull on that last bit of your answer, if you don't mind, the damage it could cause long term. Do you mind elaborating that a little bit, especially as it relates to, recruiting the talent to the government, to public service who actually has the knowledge and the specialty and the competence to do the job? What types of dangers do you see if this continues?
Well, I've just seen career prosecutors who have served, again, Republican and Democratic administrations over and over again. These are the knowledge sources in the department in different areas. These are the people who mentor young lawyers. And when you take them away, those young lawyers don't have anybody to learn from. My experience in the department, again, doesn't matter, the administration. These are not partisans. They're people who have decided they don't want to make a lot of money. They're not looking for fame. They just want to do good work. And I think when you lose that culture, you lose a lot.
Speaking of, sections within the government or within DOJ specifically that have particular skill sets and knowledge, I want to talk a little bit about the public integrity section, or PIN. That's come up earlier in the majority's hours. But what's the mission of PIN?
The public integrity section was formed after Watergate, and the section litigates complex corruption cases around the country. It does some of those cases on its own, It does, or at least during my time there, it also does cases in conjunction with, in partnership with local U.S. Attorney's Office, bringing expertise about some of the issues we've talked about today to them. And it also is a sort of clearinghouse for expertise on these issues, like the speech or debate clause or things of that nature.
Does the public integrity section play a role in checking potential abuses by DOJ as it relates to investigating members of Congress?
Well, in particular, I think it's valuable for prosecutors to make sure they get things right. They're the sort of keeper of these issues, and they're the people you go to make sure you're doing things the right way.
I guess, are you aware of some of the firings or dismantling that's been going on with the public integrity section since the beginning of 2025?
Yes.
Do you care to elaborate on how this might affect the investigations or prosecutions of public corruption and bribery case that you just mentioned?
Well, I'm concerned that the department is going to cease to have an ability to prosecute public corruption, that there's going to be the expertise necessary to do that, or the direction to do that. And so, again, I think there's short-term costs and long-term costs.
Isn't PIN also kind of a gatekeeper or for even beginning any kind of prosecution or investigation of public figures or congressional members? Like, don't department regulations require that PIN be consulted or provide approval before certain steps can be taken, or litigation can commence?
That's correct. There are several enumerated investigated steps or procedures that public integrity oversees. It's not so much for public figures, but more for, again, members of Congress, people who are in government positions where the investigations are sensitive, and it's important that we get it right and we do it, work on the same standards. Everyone works off the same standards.
And what happens when public integrity is dismantled and that protection is removed?
Well, it always existed during my career in the department, and I fear without it, there'll be, as I said, an inability to prosecute public corruption, and also a lack of expertise that when you do it, to do it the right way.
I think during the majority hour, there were some intimations that, PIN sometimes maybe rubber stamping approvals, or when, prosecutors consult with them, they just provide their clearance or approval without really engaging with the issues. Has that been your experience?
No.
All right.
Well, we're going to turn now to the classified documents investigation. We want to ask a few questions. We understand the disclosures that your attorney said at the beginning and some that you talked about during earlier questioning, but we do have a few questions that we're going to enter into the record. It'll be at Exhibit 13, which will be the superseding indictment filed in the Southern District of Florida on July 27th of 2023. It's the United States versus Donald Trump, vaulting now to Carlos de Oliveira. And when we ask questions, we're going to be referencing this document, which is docket number 85 with the court. So I'll give you a chance to look at the document. I'm sure you're very familiar with it, but as I ask questions, I will do my best to reference paragraphs in this indictment. Before we actually get to the substance of this indictment, and I might have just said this, but I just want to make it, what court did you, or what district did you actually indict Mr. Trump for mishandling of classified documents and his obstructive behavior after he left office in 2021?
The Southern District of Florida.
And can you explain to us why you sought the indictment in Florida versus, for example, Washington, D.C.?
When I took over supervision of this investigation, the investigation was pending in a grand jury in Washington, D.C. Actually, I just want to think now whether the answer to the question about venue is something If you have a filing about that, I'd be happy to answer it. I don't think there's anything about venue in this indictment, and so otherwise, I don't want to address that in the event that it's in the final report and not somewhere else.
Understood, I understand. Actually, let's just move on then to page 38 of this indictment. Let's talk about the charges that were actually brought in the Southern District of Florida. Can you summarize for us, I know we haven't gotten to it very much, but can you summarize, starting with page 38 through 52, the charges against Mr. Trump and his co-conspirators related to the classified documents that he kept after leaving office in January of 2021?
Sure. Counts 1 through 32 charge Donald Trump with willful retention of national defense information. This regards classified documents. The remaining counts relate to, and they charge Donald Trump, Waltine Nada, and then other counts, I believe, also charge Carlos de Oliveira with various counts relating to attempting to obstruct that investigation, whether it by be moving boxes so that those boxes wouldn't be found by an attorney who was doing a search of documents to return to the government, and also false statements by, I believe, both Mr. de Oliveira and Mr. Walt Nada, and I think there's also in here counts related to attempts to destroy video footage and delete security camera footage related to all three of the defendants.
Thanks. Let's walk through what you just described, but through the lens of the indictment. So let's start with page 10. I believe you talked about boxes of classified documents when you were just giving your summary. Can you describe, there's a picture on page 10. What do we see in this picture on page 10 of the indictment?
Okay, these are some of the, and it's referenced in the paragraph above. These are some of Donald Trump's boxes that were brought from the White House and then stored in various places. In this particular photograph, it shows them being stored on a ballroom stage at the Mar-a-Lago Social Club.
And do you know what, you said the ballroom, is the gold ballroom, I believe that's what's in the indictment in paragraph 26?
The white and gold ballroom, yes.
White and gold ballroom. What was the purpose of including these photos in the indictment?
I think it was important to lay out the facts of our case, and sometimes a picture can lay out the facts more clearly than words, and can make the words have more clear meaning. And so here, I think they show the sort of circumstances in which these boxes were being kept, boxes that contained highly classified documents.
So going along that same theme, if we go to page 12, there's another picture of, it appears, boxes. Can you describe to us, and I believe it's in the indictment, so in paragraph 30, but can you describe what we see in this picture with the boxes on this page 12 of the indictment?
Yes, I think the photo on page 12 actually refers to the paragraph before that, the paragraph 29, and this is, the indictment lays out that these boxes were moved around to various locations where lots of people had access to them. After they were on the ballroom stage, they were in a business center, and then moved to a bathroom and shower in the lake room. And you can see that you can see the shower curtain behind the boxes. And so that's the room that's referred to there.
And the last picture I'm going to ask about is on page 14. And on paragraph 32, it looks like Mr. Nata texts another employee and says, quote, "I've opened the door and found this," and Nata attached two photographs that he took of the spill, it looks like, of documents. Can you describe this picture as well, which is on page 14 of the indictment?
Sure. So this refers to paragraph 32 of the indictment, and I believe it's blurred out in this picture, but one of the classified documents that's actually charged in the case is visible in this picture. I think it's count 8. And this is a room where others had access to. Obviously, someone was able to go in there and spill this box of documents, and Mr. Nada took a picture of it. So I think it shows how accessible these documents were and the sort of manner in which they were, the care with which they were kept.
The court-authorized search of Mar-a-Lago has been subject of lots of discussion on this committee. I think an important question to ask, I want to reference paragraph 38 on page 17, was whether any government agencies or individuals within the government had tried or attempted to collect the classified documents from President Trump after he left office in January of 2021.
Yes. Sticking specifically to the indictment we have in front of us, beginning in paragraph 38, these paragraphs detail efforts by the National Archives and Records Administration to recover, I think the originally, it wasn't to recover classified documents, it was to recover presidential records that were missing. In the effort to do that, and as you can see, that took several months. What they eventually got was a number of boxes. I believe it was, I think he said it was going to be 12 boxes, and then it was 15 boxes, yes. What came back was a large number of highly classified documents, including secret documents, top secret documents being documents that would cause grave danger to the national security.
Turning to page 21, paragraphs 51 and 52, did the FBI open a criminal investigation into the potential classified material at Mar-a-Lago after President Trump left office in January of 2021?
That's correct. The dates are stated here. And that was obviously before I became special counsel.
And did a federal grand jury open an investigation, which I believe is referenced in paragraph 52?
Correct.
And why did the FBI open its investigation, the federal grand jury open its investigation based upon the referral of an agency? And I believe it might be referenced in paragraph 50.
Yes, there was a referral by NARA to the Department of Justice on February 9th.
Staying on page 21, after opening its grand jury investigation, did the grand jury issue a subpoena for all documents with classified markings?
Yes, and you're referring to paragraph 53, is that correct?
Yes, sir.
Yes, the grand jury did.
So after sending out this grand jury subpoena, I believe this is when the most of the obstructive conduct takes place. And so we're going to be flipping through pages 21 through 26 of the indictment. And I believe the indictment even titles this conduct as the defendant's concealment of boxes. Sticking to the indictment, can you summarize for us the efforts that the defendant took to conceal the boxes of classified documents in Mar-a-Lago?
Sure. So paragraph 53 references the fact that a grand jury subpoena was issued on the 11th of May, and that two attorneys representing Donald Trump informed him of the subpoena, and he authorized them to accept service. So he was on notice of the subpoena at that point. 11 days later, Walt Motto, who was the parlance, I think, is his body man. He'd previously been a valet for him at the White House. Went into the storage room, which was the landing place, the last place these boxes were, and left 34 minutes later carrying one of President Trump's boxes. The next day is the day that Donald Trump met with his attorneys to discuss the subpoena. They told him that they would need to search for the subpoenas and provide a certification to show that they were in compliance with the subpoena. And below that is a number of statements that one of those attorneys memorialized that Donald Trump said during that conversation. And paragraph 56 would be as well. Paragraph 57, Donald Trump confirmed his understanding that one of those attorneys would return to the club on June 2nd to search for any documents with classification markings to satisfy the subpoena. And Donald Trump indicated that he actually wanted to be there that day when he returned to look at the boxes. He told the second attorney that second attorney didn't need to be there. And so after that meeting, he had planned to depart Mar-a-Lago, but he changed his summer plans to be there on the 2nd when the first the attorney came to review the boxes.
I'm going to stop you real quick.
Sure.
So I want to make sure this movement of boxes is clear from the indictment, and I want to reference paragraph 59, I believe. So it sounds like you were able to determine, the evidence showed from this indictment, that Mr. Trump directed Mr. Nata to remove the boxes of documents from the storage room in Mar-a-Lago. Is that correct?
Correct.
And how many boxes in total did Mr. Nata remove from the storage room in Mar-a-Lago? And I believe it's referenced in paragraph 59 as well.
Yes, I believe, as it says in paragraph 59, between the 23rd of May and I think it was June 2nd, he removed at Donald Trump's direction a total of 64 boxes and brought them to Trump's residence.
And he took them to Mr. Trump's residence from the storage room, is that right?
Yes.
And just to confirm, Mr. Nata moved these boxes just a day after Mr. Trump met with his attorneys about responding to the grand jury subpoena, is that correct?
Well, yes, he actually, the first day that is listed here is in paragraph 54, when he moved the first box, and then yeah, so then if you look at paragraph 59, subsection A, 3 boxes were moved on the 24th. On the 30th, Trump and Nauta spoke by phone for about 30 seconds, and very shortly after that, over a period of a little less than 2 hours, Nauta moved another 50 boxes from the storage room. That same day, there was a text exchange between Nauta and the president's wife, and in that, she, I'm summarizing here, but it's on paper. She was saying, we're not going to have room for all these boxes on the plane, and Mr. Nauta replied, I think he wanted to pick from them. I don't imagine him wanting to take the boxes. He told me to put them in the room and that he was going to talk to you about them. And then on the first, 11 more boxes were moved out of the storage room.
So let's, that's a lot of movement of boxes, right? And it makes sense that it's under the concealment of evidence section of your indictment. I believe going to paragraph 63, you provide a pretty succinct summary of the number of boxes that were moved versus the number of boxes that were returned to the storage room. So do you mind summarizing that piece for us so we understand exactly how many boxes were left in the summary room?
So paragraph
Or the storage room, sorry.
Sure. Paragraph 63 summarizes that between May 23rd and June 2nd, Nauta, at Trump's direction, moved 64 boxes from the storage room to the residence. And then afterwards, Nauta and De Oliveira returned to the storage room only 30 boxes.
So there were only 30 boxes left in the storage room, although there were 64 boxes that were at Mar-a-Lago, to your knowledge, based upon this indictment.
Well, they returned 30. How many more were still in there that they hadn't taken at all? That would be added to that.
Why was there any significance to moving all these boxes prior to June 2nd of 2022? And I believe this is referenced in the false certification of the FBI section of the indictment. But what's the significance of moving all these boxes just before June 2nd of 2022?
because Donald Trump was on notice that his attorney was going to search that room, search for classified documents in that room, and in between the time he was put on notice of that and the time that that he actually did that, at Donald Trump's direction, 64 boxes were taken out, but only 30 were returned.
So how many boxes did Mr. Trump's attorney actually review when he returned to Mar-a-Lago for the review on June 2nd of 2022? And again, I believe this is in the false certification section of the indictment.
Right. The attorney looked through all the boxes that were in the room and located, reviewed the contents of the boxes in the storage room, and he located 38 documents with classification markings that he took out and he put in a red roll folder, and that he then taped up.
Did the evidence show in the indictment that Mr. Trump's attorney believed that he had reviewed the entire universe of documents at Mar-a-Lago?
I'm trying to see if that's here in the indictment. I could answer that question. Well, I can't answer anything that's not in this indictment, but
And just to make it clear for the record, why can't you answer anything that's not clear in this indictment?
well, that issue, the question of whether he reviewed, in his view, all the boxes. If the answer to that would be within the final report, and again, I don't have a recollection one way or the other, unless there's another public filing about that. My understanding is I can't discuss issues like that due to the injunction.
Understood. Let's move on to the next section about the attempt to delete security camera footage. And we're working our way up to this August court-authorized search of Mar-a-Lago, if you can't see where we're going here. So on page 27, that's the section that starts the attempt to delete security camera footage. Did the evidence show that Mr. Trump attempted to or tried to direct someone else to delete security camera footage at Mar-a-Lago?
Yes.
Can you please describe from the indictment for us what evidence showed that Mr. Trump directed someone to delete security footage at Mar-a-Lago?
Well, just speaking to what's in the indictment, not anything outside it unless you direct me to public filing. It starts on paragraph 74 and it goes through paragraph 87. Is there any particular part you'd like
Yeah,
me to
so I'm going to
address?
start with June 22nd of 2022. It's paragraph 75. I believe the Department of Justice sent a message to an attorney for Mr. Trump's business organization that might have provided knowledge for him. What was emailed to an attorney for Mr. Trump's business organization that kind of started off this process?
There was a draft grand jury subpoena for the production of security camera footage. And the previous paragraph notes that agents had observed surveillance cameras near the storage room where the classified documents were stored. And so a draft subpoena was sent on the 22nd of June.
Yes. And then following the draft grand jury subpoena being sent to the attorney for Mr. Trump's business organization, it looks like Mr. Trump had a phone call with Mr. De Oliveira the day after on June 23rd of 2022. Is that correct?
For 24 minutes.
Yes. And then the actual subpoena was sent by the Department of Justice to an attorney for Mr. Trump's organization on what day? And I believe this is in paragraph 77.
Yeah, Friday, June 24th.
And what was that subpoena? What records was it requesting?
Any and all surveillance records, videos, images, photographs, and/or CCTV from internal cameras at certain locations at the Mar-a-Lago Club, including on ground floor basement, from January 10th to June 24th of 2022.
Notably, the same day that the Department of Justice emailed Mr. Trump's attorney the actual final grand jury subpoena, it looks like Mr. Trump may have tried to reach out to Mr. Nauta, and it's described in paragraph 78. Do you mind discussing or telling us what this interaction might have looked like between Mr. Trump and Mr. Nauta?
What paragraph 78 describes is an attorney for Trump speaking to Donald Trump about the subpoena for security footage. A little over 2 hours later, Waltine Nada received a message from a coworker indicating that Trump wanted to see him. And then less than 2 hours after that, Nauta, who was supposed to be traveling with Trump to Illinois that day, changed his plans to travel and began making arrangements to travel to Palm Beach instead of Illinois, where he was scheduled to be with Trump.
So fast forward to paragraph 80, the same day, we're still on June 24th, right? So Mr. Nauta changes his travel plans, and then Mr. Nauta and Mr. De Oliveira, it looks like they reach out to a Trump employee. What position did the Trump employee have that Mr. Nauta and Mr. De Oliveira reached out to? This is in paragraph 80.
Let's see. He was the Director of Information Technology.
And what was, and this is in the subsection of paragraph 80, subsections A through E, what was the nature of the conversation between Mr. Nauta, Mr. De Oliveira, and the Director of Information Technology at Mar-a-Lago Club?
Paragraph 80 reflects a series of contacts and conversations. First, Nauta reaching out to the Director of IT, asking if he's around. Nauta then also reaching out to De Oliveira, and it appears they had a call after he reached out. And then that same employee, the Director of IT, texted back to Nauta that he was available. Nauta responded to that. At 6:56 that same day, De Oliveira texted the Director of Information Technology saying, "Hey buddy, how are you? Walter called me early, said it was trying to get in touch with you. I guess he's coming down tomorrow. I guess needs you for something." And the employee responded that he reached out but didn't say what he wanted. I told him I'm local, entertaining family that came from New York City, and he told me no worries. And then the last entry is Trump, that same employee, the Director of Information Technology, texted Nauta to say, if you need me, I can get away, just let me know. Nauta responded saying, sounds good, thank you.
So fast forwarding to paragraph 82, because now we're moving on to the next day, which is June 25th. After having these conversations, it looks like Mr. Nauta and Mr. De Oliveira actually go and look at some of the information technology at Mar-a-Lago Social Club. Can you tell us what Mr. Nauta and Mr. De Oliveira, who did they go visit? I think they went to a security guard booth, is that correct?
Yes, there's a security guard booth where at that booth, it has where the cameras are, so you can see where the surveillance cameras, like that would be where you could see them. And then they walked with a flashlight through the tunnels where the storage room was located and observed and pointed at the surveillance cameras that were there.
And then Monday morning, first thing in the morning, or 9:48 a.m. in the morning on Monday, June 27th, 2022, and I'm trying to keep this tight timeline going. It looks like Mr. De Oliveira continues talking, or at least visiting, other IT officials at Mar-a-Lago. I believe this is in paragraph 83 and 84. Do you mind summarizing what happened just 2 days later on June 27th of 2022? And as you can see, we're building our way up to July and the August court-authorized search of Mar-a-Lago.
So that day, this is paragraph 83 and 84, De Oliveira walked to the IT office where this same Director of IT was working with another employee. There were two people there, and requested that the Director of IT step away so he could talk with him. They left the area and they walked through a basement tunnel to a small room that was known as an audio closet. And once inside that closet, he being De Oliveira, told the employee first that their conversation should remain between them, He then asked how many days the server footage was retained, and the employee told him approximately 45 days. And then De Oliveira told the employee that the boss wanted the server deleted. The employee responded that he would not know how to do that, and he did not believe he would have the rights to do that. Trump employee, that same employee told De Oliveira that De Oliveira would have to reach out to another employee who was a supervisor of security for Trump's business organization. But De Oliveira persisted and insisted that insisted to Trump employee for that the boss wanted the server deleted and asked, what are we going to do?
That same day, so June 27th, I believe, of 2022, did the evidence show that Mr. Trump had any conversations with Mr. De Oliveira? And I'm referencing paragraph 87.
Yes, on 3:55 p.m., they spoke for about 3.5 minutes.
So we're on June 27th of 2022, and then we move to July of 2022. Did the FBI and grand jury actually obtain any of the surveillance that they requested through their grand jury subpoena?
They did.
And then following the FBI and grand jury obtaining the surveillance video, can you explain what happened? And this is referenced in paragraph 89.
Sure. The FBI executed a search warrant at Mar-a-Lago. The search warrant was authorized the FBI to search and seize, among other things, all classified documents. There's one thing I just want to correct, though.
Yeah.
The chronology we've gone through, all of those facts were not known to the FBI at the search warrant. Many of them were, but for example, this last bit where we talked about attempting to delete the server, that was not uncovered until later.
Thank you. And during the execution of this court-authorized search of Mar-a-Lago Club in Florida, did the FBI actually seize any documents with classified markings, classification markings?
Yes.
And approximately how many documents did they seize with classification markings?
Paragraph 90 states that they seized 102 documents with classification markings. And there's a chart that lists the level of classification and where they were found.
And just a note for the record, some of the classification markings that were found included top secret classification markings, secret and confidential, and as you just said, for a total of 102 documents.
Yes, and if I could, I want to correct something I said before. I stated what it means if a document's top secret, and I said it is grave damage to the national security. Actually, a top secret document, and I'm looking at paragraph 14A, is information that reasonably could be expected to cause exceptionally grave damage to the national security. Secret is grave damage to the serious damage to the national security.
Going back and taking a step back to the actual Mar-a-Lago Club, and this is referencing paragraphs 11 through 13. Was the Mar-a-Lago Club a place that members and staff frequently attended or was in the presence of or on the location of Mar-a-Lago?
Can you direct me to a paragraph again?
Paragraphs 11 through 13.
And I'm sorry, what was your question?
Were there hundreds of members of the Mar-a-Lago Club?
Yes, there were hundreds of members and 150 full-time or part-time or temporary employees.
Were some of the members or people who attended Mar-a-Lago, were they foreign nationals?
I can't answer that question.
Were any of the staff that might have worked at Mar-a-Lago foreign nationals?
Both of those are questions I can't answer because they're not in the indictment here. If you have a filing about that, I'm happy to answer those questions.
And were any of the temporary employees, were they foreign nationals?
Same answer.
In addition to just the members and the staff that were there, what types of events might have been held at Mar-a-Lago where these classified documents were found during your court-authorized search in August of 2022? And this is referencing paragraph 12.
So paragraph 12 states that in the period between January 2021 and August of 2022, the club hosted more than 150 social events, including weddings, movie premieres, fundraisers, And those events together drew tens of thousands of guests.
We're going to enter into the record 2 exhibits. I believe they'll be exhibits 14 and 15. Thank you. Exhibit 13 will be a House Judiciary GOP tweet that says, "This is what happens in third world countries, not the United States. Doesn't the FBI have better things to do than harass the former president?" And this tweet is from August 8th of 2022. And then exhibit 15 will be an August 8th, 2022 tweet from Speaker Kevin McCarthy that says, "Attorney General Garland, preserve your documents and clear your calendar." What is your response to statements, and actually I want to preface this by saying, look, I understand that you were not the special counsel when this search was conducted in August of 2022, but what is your response to statements made accusing the FBI of harassing Mr. Trump in the aftermath or after the FBI conducted its court-authorized search of Mar-a-Lago?
I don't think those statements are accurate.
Do you, can you explain why you do not believe they're accurate?
The search of the Mar-a-Lago Social Club was conducted pursuant to a warrant, a search warrant, as the Department of Justice and FBI does every day, continues to do every day. It was approved by a United States magistrate, and
In your prosecutorial experience, can you describe what types of factors a prosecutor would have considered before seeking a court order to search someone's home or private residence?
well, most clearly, you would need to have a factual support for that basis, and a reason to believe that evidence of a crime would be recovered, and probable cause to believe it would be recovered at the location you're asking to search, based on the facts.
And that's kind of, we just went through for the indictment, the various paragraphs we just went through in the indictment, is that correct?
That's correct.
Can I just wrap that
Yes,
up in a
please.
bow? So
Yes, please.
before there was the court-ordered search at Mar-a-Lago, your folks went before a court and established probable cause that a crime had been committed and that evidence of that crime would be found at the site of the search, Mar-a-Lago.
It was before I was special counsel, but yes, they presented an affidavit to a court, and that court approved a search warrant.
Okay, thanks.
And even earlier than that, I mean, would you say that President Trump had multiple opportunities to return the classified documents that he had retained back to the federal government voluntarily?
Yes,
He had an opportunity to return them when the National Archives first asked for them back, right?
yes,
And then he also had another opportunity to return them when he was subpoenaed by the grand jury, right?
correct.
And he did not return all the documents during that time, right?
That's correct.
And based on your indictment, is there information that led you to believe that he was aware that at least some of these documents are highly sensitive documents?
Yes.
Can you draw any conclusions about his refusal to return those documents in spite of having been given multiple opportunities?
I don't think I can answer that question because it may involve non-public facts that are part of the final report that is currently under an injunction.
Can you draw any conclusions about his motives for refusing to return those documents?
Unless you can point me to a filing or a public filing on that issue, I don't want to run any risk of running afoul of the injunction, and so without a public filing on that issue, I don't think I can answer that.
Just one last question. Did you come across in the course of your investigation any evidence about why President Trump took those documents in the first place?
Again, I don't think that's in the indictment here, and unless you have a public filing, that, given the current state of the injunction, I don't think that's a question I can answer.
Thank you.
So starting in paragraph 33 on page 14. Mr.
Sorry.
Okay.
Oh, yeah. I mean, just one other fact to mention, this is my counsel just gave me, this is a filing on the docket of Southern District of Florida. This is an order from Judge Cannon on June 27, 2024, denying a Franks hearing.
We'll make that an exhibit.
Yeah.
We have that.
And this issue about whether there was in fact probable cause for the search warrant was litigated, and the judge denied the motion for a Franks hearing. And found, and this is in footnote 2, that the defense motion does not even meaningfully challenge the presence of probable cause in the affidavit.
Thank you. We've marked this order denying the motion for a Franks hearing, which I believe is document 655 dated June 27th, 2024. We marked it as Exhibit 16. I know with the, how much time do I have left? 5 minutes? Okay, about 6 minutes. All right, my remaining time, I want to talk about, and direct you to paragraph 33, and I believe this focuses on conversations at the Bedminster Club. The Bedminster Club is separate than the Mar-a-Lago Club in Florida, is that correct?
Yes.
Okay. And the Bedminster Club's in New Jersey? Is that your recollection from the indictment?
Yes.
In paragraph 36, you detail a meeting at the Bedminster Club in August or September of 2021. What can you describe what happened in this meeting and whether Mr. Trump shared classified information?
Well, I just want to start by saying I don't feel like I can say anything more than what's in the indictment here, unless you point me to anything otherwise. So I can read a portion if you want.
Please.
Well, in paragraph 34, references on July 21st of 2021, Trump gave an interview, and this was when he was no longer president, at Bedminster. 2 members of his staff were there, and the interview was audio recorded with his knowledge and consent. Before the interview, media had published reports that at the end of Trump's term as president, a senior military official purportedly feared that Trump might order an attack on Country A, and the senior military official advised Trump against doing so. Paragraph 35 says, upon greeting the writer and publisher and his staff members, Trump stated, quote, "Look what I found. This was senior military officials' plan of attack. Read it and just show it's interesting." And then following that, there are additional statements that Donald Trump made regarding the document that he was showing and what other people in the room said.
Going to paragraph 36, did the individuals that Mr. Trump shared this information about the ongoing military operations with, did they have the security clearance or need to know about the classified information about that military operation?
In paragraph 36, it states that the PAC representative did not have a security clearance or any need to know classified information about the military operation.
Are you aware of whether the FBI conducted a similar search of Mr. Trump's residence at Bedminster?
Whether that happened or didn't happen, I'm just trying to be very cautious. I don't think I can answer that due to the injunction.
Do you think that the FBI was able to retrieve all the classified documents that President Trump improperly retained after he lost the 2020 election?
I'm struggling because I can't recall if that is in the final report, and because I'm not sure of whether it's in there, I don't think I should answer that question.
All right, we'll go off the record.
Record marking Exhibit 17. This is on the topic of the misordering of the documents, and there's a filing that I wouldn't ordinarily mark, but given the situation on the Florida case, we'll mark that because your office addresses what came to be a misordering of the documents. And so the question is, do you have any information about how the documents that were seized from Mar-a-Lago were misordered?
Let me start by saying I think there's also another filing on this
Okay.
that we did later as well. So between those two filings, what I can tell you is when a search warrant is executed at a location, there are documents in boxes. The search warrant can be executed in a manner where you just take out the documents that you're looking for, or you take the box with the documents that surround that. Both ways are proper. In this particular case, obviously the search warrant happened before I was special counsel, and the special master litigation occurred, or began certainly before I was special counsel. In that litigation, my recollection is that President Trump's attorneys took the position that the government should not have even taken all the documents in the boxes and just taken the classified documents, such that if things were done the way they proposed, there would not be other documents in the boxes. It would just be those. As I think we set forth in our filings, when this issue got raised initially in court, our attorney misstated that the documents were in fact in the exact order that they were found. I think you can see from the timing of these filings that once we realized that was incorrect, we corrected it with the court as quick as we could. And then at that point, when President Trump's attorneys were now alleging that this was an important issue, we looked into in more detail exactly why it was not possible to keep the documents in the exact order. And I would just say everything I say today I'm deriving just from the filings we did on this. But my recollection from those filings is that one of the central issues about keeping the documents in the same order is that President Trump kept these incredibly highly classified documents in boxes with all different sorts of things of all different sorts of shapes and sizes. Clothing, memorabilia, newspaper clippings, things of that nature. And so while agents, I think, sought or wanted to keep the documents in order as best they could, I think once they saw the order of these boxes, clearly that was going to be an impossible thing to do. And so we set out our views about that in these filings. And again, I'm speaking only from these filings.
What's the upshot of the documents being taken out of order?
My view is there is no upshot in the sense of these documents were, staff members referred to these documents as the, quote, beautiful mind boxes, meaning they were, and this wasn't just one staff member, it was multiple staff members, and they referred to the fact that Donald Trump, these were his boxes, they were exclusively his belongings in them, he had curated them and what was in them. And so in our view, that was not a live issue in the litigation. Once the defense raised it and said, oh, now that you can't say what order they're in, we think that's a big issue, we responded. But I think ultimately in the litigation, given President Trump stated that he believed these were all these were his documents. And so the litigation in this case, in my view, was not going to turn on the location of documents in the boxes, given his position was, all of this is mine.
Do you know if he was intending to save those materials for his presidential library?
You mean the classified documents?
The items in the boxes, all of them.
Well, if his defense were that he was intending to take classified documents that he had no authority to take, and he did it intentionally because he wanted to start a presidential library and keep those documents in the locations that we talked about today, that's a crime.
No, but my question was all the items in the boxes, the shirts and the other mementos, were they being saved for a presidential library? To the extent you were able to develop that in the course of your investigation?
You know, I mean, there were newspaper clippings in there. There were, I think, you know, different sorts of things that wouldn't to me seem like the sort of things that would be in a presidential library. To be honest, I've never been to a presidential library, so, but if I were starting one, I don't think that's the sort of things I would put in it.
Okay, but you didn't develop any evidence during the course of your investigation that the materials were intended to be saved for a presidential library?
I don't recall that, and I also want to be careful of not getting outside the parameters of these filings, because I don't think we addressed that issue in the filings we're talking about.
Okay. And during the times relevant that we're discussing, Mar-a-Lago was protected by the Secret Service. Is that correct?
That's correct.
So to the extent an adversary wanted to come in and steal some of these classified documents, they would have had to go through the Secret Service to get them, right?
Well, as we alleged in paragraph 13 of the indictment, the Secret Service provided protection services to Trump and his family after he left office, including at Mar-a-Lago, but it was not responsible for the protection of boxes or their contents, and the indictment states that Trump did not inform the Secret Service he was storing boxes of classified documents at Mar-a-Lago, meaning they didn't know that they were protecting classified documents.
Right. But if Joe Q. Citizen had classified documents from their time serving in government and they brought it home to their basement, and some foreign adversary was aware of that, it would be much easier for a foreign adversary to break into the Joe Q. Public's basement and take those classified documents. If the foreign adversary wanted to go and get those documents out of Mar-a-Lago, it would have been a lot more difficult. I mean, a person can't just walk into Mar-a-Lago and try to abscond with these materials, right?
I would very much like to answer that question, but I cannot answer that question due to the final report.
Okay. Was there an effort by your office, did you consider seeking the removal of Judge Cannon?
Again, I don't think that's in any public filing, and so I cannot address that given the injunction.
Whether, you know, the internal office discussions involved consideration of removing Judge Cannon? I mean, that's not something you can talk about?
I don't think I can talk about things today, again, consistent with our discussion this morning. If it's not in a public filing, I haven't seen the final report in almost a year. I'm not comfortable discussing issues like that solely because of that issue.
Okay.
I'm trying to be as consistent as I can about that.
Okay. The book by the Washington Post reporters that we were referencing earlier reported that you considered, and by you I mean your office, your collectively, the collective you, considered petitioning the removal of Judge Cannon, but the Solicitor General's office recommended against it because and if you had gone to the Attorney General, that would have had to been reported to publicly reported to Congress. Is that something you have a recollection of?
Mr. Castor, sorry, I just, on this point, I just want to make sure that we're in agreement that the Department of Justice has taken an expansive interpretation of Judge Cannon's order in its application to Mr. Smith, and that he's not permitted to disclose non-public information that may be contained in Volume 2 of the Special Counsel's report. And I know you cited this book, but the email that we both received from the Department of Justice this morning said that this prohibition does not apply to information that has been made publicly available through authorized means. And so if something was leaked to some reporters who wrote a book about it, I would not consider that to be made publicly available through authorized means.
Okay. You got a page? I'll noted, and I'll just to give more context to what I asked, it's on page 349 of the book. It states, the final straw for Smith came when Cannon dismissed the documents case, citing as a basis Thomas's concurring opinion, which carried zero legal weight, making the choice a striking departure from judicial standards. Solicitor General Elizabeth, how do you say her? Is it Prelager?
Prelagar, I think.
Prelager? Okay, excuse me. Ultimately approved the appeal of Cannon's ruling, but the former Garland law clerk rejected Smith's plan to seek to have Cannon recused, saying he didn't have enough evidence to try to remove her. Smith could have asked Garland to reconsider his trusted counselor's position, but he did not. If Garland turned him down, it would have to have been reported to Congress. And so I guess the question in light of your counsel's observation is, if you asked the Attorney General for something and he turned you down, wasn't your understanding that it had to be reported to Congress?
So putting aside this whole
Yes.
situation, I believe it states something to that effect in the special counsel regulations.
Okay, and was that something you were concerned with? That you wouldn't want something like that reported to Congress?
That was not a concern of mine.
Okay. I believe earlier you indicated you did not have any communications with White House officials. I think that Martin already asked you about whether you spoke with President Biden. You said no. Did you have communications with any White House staff?
I did not.
Okay. Did anyone in your office?
My office interacted with staff in the White House in the following ways. There was one instance where, that I recall, where we sought to interview a career National Security Council staffer, and to make arrangements to do that interview, we had to do it through the White House. With respect to the classification of the documents that we were using in the classified documents case, there were some of those documents the National Security Council had equities in, and as a result, we needed a contact point to speak to, I believe it was to speak to a career person who could be our contact point for that classification review. And so there was interaction between my staff and people, I believe, from the White House counsel's office. I would add that all of my understanding and my direction was that any interactions would be pursuant and consistent to the White House contacts policy. Okay. And I think also in the beginning of my time as special counsel, there was this litigation I referenced previously about executive privilege, and we noticed both the current White House and though I don't know that we had to, we noticed also President Trump on that in terms of whether they would waive executive privilege or not. I think in that instance, I'm not sure of this, but I think in that instance, we requested the DAG's office to ask the White House about that, and so we didn't have direct contact, but I wasn't involved in those contacts, so I'm not sure.
Okay. So nobody in your office had communications with White House Chief of Staff Jeff Zients?
Not that I recall.
And nobody had communications with the counsel's office in terms of your strategies for prosecuting these cases?
No.
In conjunction with your final report, a letter was prepared by President Trump's defense counsel, Todd Blanche and John Lauro, and they raise issues concerning their review of the report over the Christmas season. And they indicate that they were placed in a veritable hardship trying to review the report because the special counsel's office required them to come to DC. The special counsel's office wouldn't let them, use their laptop. They wouldn't, have access to any, internet. Can you walk us through your posture on some of those onerous conditions that defense counsel raises?
Sure, and just for clarity, I'm going to confine my remarks to the election side case because whatever letter they sent or didn't send regarding the classified documents case, I don't remember if there was a letter, but I don't want, for the reasons we talked about, talk about that.
I am referencing the letter in the part 1 of the report.
Okay, great. So I do recall that, and I recall being surprised and disappointed about their letter on that point because my recollection is that I'm not going to remember the specific dates, but I remember we gave them a time period and conditions to look at the report, and it was around the Christmas holidays, and they were unhappy with those conditions, and we then changed the conditions to better suit what they wanted. And I think this is in what I'm talking about, if I recollect it correctly, this may be in the letter that we attached to to the final report as well. And I remember them expressing appreciation to us for allowing them to change the schedule. That's my recollection of that. So when they complained about the schedule, I remember being surprised about that.
Okay.
And again, the letter that we wrote, I believe, reflects this, and that letter will be a better recollection of this than my memory a year from now.
They indicate in that letter, though, that they were required to delete prior discovery productions, preventing them from reviewing the underlying documents referenced in the report.
Well, the deletion of discovery, that was pursuant to the protective order in the case, and so put aside the final report of their review, the protective order that both parties signed, and again, there'll be a record of this, that protective order stated that when the case was concluded, the discovery had to be deleted, and that was an order that both sides signed with the court, so that was as much an obligation on their part to the court as to us, and by this point in time, the case is as to Donald Trump had been dismissed, whatever date that was in November.
Right, but they're reviewing the final report to try to, position their client to, make some rebuttals and that type of thing, which is certainly, I think you would agree, is a fair reason to want to have access to the report, correct?
Yes.
What types of communications did you or your staff have with the January 6th committee?
So when I was appointed as special counsel, I asked at some point whether we had gotten evidence from the special counsel, from the select committee. We had not, and so I directed my staff to get that evidence, get whatever evidence we could from them, and I think it was in December or so that we did, in fact, get evidence from them and get a copy of their final report. And this is this is referenced in the in our final report. There's a paragraph or footnote regarding that.
Okay. Do you know who at the select committee your staff was communicating with? Were you?
I was not.
Okay, so you didn't have any communications with members or staff at the select committee?
I did not, no.
Okay, and who on your staff did?
What I recall is tasking J.P. Cooney to do this. I don't know if he then tasked somebody else or if he did it himself or with somebody else, but that's who I remember speaking to about this.
Okay. the book we've been referring to reports that on January 1, less than 48 hours before Republicans could lock down all the evidence or perhaps delete it entirely, I don't think we would do that. A committee staffer summoned an attorney from Smith's team to Capitol Hill to receive a hard drive containing the committee's work. Is that consistent with your understanding of what happened?
I wouldn't have remembered that level of detail if you hadn't read it, but we asked to get everything they would give us, and we took everything they gave us, and we disclosed to the defense everything we got.
Okay. You disclosed everything you received from the
Yes,
January 6th
the stuff we
committee?
got from the January 6th committee, I directed my staff to disclose it to the defense.
And the book reports that, Cooney drove to the Capitol and at the last minute succeeded in collecting 2 hard drives containing about 200 interview transcripts, less than 24 hours before Republicans began shutting down the committee's website. Is that something you have any recollection of?
That level of specificity, I don't. I can't say that that's not accurate, but I don't recall that level of specificity.
And do you know if the hard drives that you obtained contained video of the interviews the January 6th committee conducted?
As I sit here right now, I don't recall one way or the other. If they were in there, we looked at them and we provided them to the defense, but I don't know one way or the other.
And when it comes to deleting documents, while the Republicans didn't do that, what I can tell you is that the January 6th committee files, when we were able to have access to them, did not include the videos that they recorded. And so the question is, do you know, and I apologize if I'm repeating this, but do you know if the special counsel's office, took possession of the videos of the interviews? Because we didn't get it, they were gone by the time we had access to it.
Yeah, as I sit here now, I don't know. What I recall is give us everything you can, give us any evidence you can, and then we review that evidence and disclose it to the defense. What it included in terms of that level of specificity, I don't have that recollection right now.
The videos that they used at their at the public hearings were obviously snippets, and they were they were cherry picked. I don't really mean that in a pejorative way, but they were selected to make the points they wanted to make. And if there was a defense attorney involved with the proceeding, if there was an active minority involved with that proceeding, we would have had a chance to point out that the videos are selectively edited and didn't have the full context. And you would agree as a prosecutor that if there is a video, you'd want the whole video, not just the snippet.
Yeah, we asked for everything they would give us, so we wanted whatever they were willing to give us.
Okay. Let's mark the next exhibit, which will be number
18 and 19.
These are exhibits relating to
Thank you.
what I referenced during our last hour about President Trump's access to classified information. Was it your understanding that the skiff that was in existence at Mar-a-Lago before President Trump, left office, was it your understanding that there was a possibility they could have recommissioned that skiff?
Can I just take 1 minute to look at this?
Of course.
Yeah. Okay. Thank you for allowing me to look at that.
Sure. So you would agree if an individual, not necessarily President Trump, is being prosecuted for mishandling classified information and is going to trial, you would agree that putative defendant would have, ought to enjoy the ability to discuss the charges in a skiff with his lawyer, correct?
Yes.
Have an ability to review the documents in question in an environment with his lawyer, correct?
In a skiff, yes.
Right. Now, if, in President Trump's case, he had a decommissioned skiff at Mar-a-Lago, correct?
I am not sure about that. That may be true. I don't recall that, but
Okay.
I'm not, if there's a filing that says that,
Do you have any recollection, did the defense ask that, the skiff be recommissioned or a secure area at Mar-a-Lago be established so that he can have these communications with his lawyer?
what I recall is that there was a skiff at some point at Mar-a-Lago, or a temporary skiff sort of thing. When you say decommissioned, I didn't know that there was anything like a skiff, unless you can show me something otherwise. I don't remember there being a skiff like there that was like there but not being used. I'm not sure. And again, maybe that's my recollection, but our position about this is reflected in this filing, and it's in sum that the government was not aware of any case in which a defendant had been permitted to discuss classified information in a private residence. And this would be exceptional treatment consistent with the law. I'll just add one other thing that might be helpful is we did work with the FBI to make Donald Trump's review of classified information at this skiff, and I think it was in Miami, more convenient and easier. I do recall having conversations to do that. We did oppose him having classified documents at his home and social club, which is the same place where he was keeping these illegally. So that is accurate.
Right, but if a skiff was established, I mean, this isn't just any normal person. This is the former President of the United States, now current President of the United States. And, if a skiff could be recommissioned at the Mar-a-Lago residence, I mean, why would you have an issue with that?
Well, I think you just hit on it. Any normal person. He should have the same rules as everybody else. And he, at this time, was a private citizen. And I'm not aware of any private citizen in a litigation, no matter how important a person they are, no matter how busy they are, being allowed to have a skiff in their home for their convenience. Again, I think my recollection is we worked to make his review of classified documents at the skiff, and I think it was in Miami, more convenient. And we did that, but I did not think it was appropriate because I think he should be treated like anybody else.
Okay. Initially, in the documents case, sorry, not the documents case, the DC election case, how quickly did you want to proceed to trial after that case was indicted? What was the time frame, if you remember?
I know we requested a trial date. There's a public record of this. I think the judge had a status conference where we discussed it. We proposed a date. They proposed a date in 2026. The date that the judge chose was not the date that we proposed, but was, I think, 2 months after the date we proposed. I'm going to say I'm going to guess 4 months, but there's a record of that.
Right. Yeah, I think the special counsel's office proposed initially trying President Trump in January of 2024. The judge, Judge Chutkin, came back with the Super Tuesday date, which of course raises a whole other set of questions which aren't necessarily directed to you. But do you think in hindsight that, I mean, how many months, was that 4 or 5 months after when did the indictment drop? Was it August?
The indictment was in August.
August 1st of 2023?
Thereabouts. I don't remember the exact date.
Okay. So we're looking at 4 months or 5 months, depending on when it is in January. That's a pretty aggressive timeline, isn't it?
We organized the discovery in a way that we felt that that was a fair date.
Do you remember, as you sit here today, how many pages of documents there were for that case?
I don't.
Okay. Does the number 13 million, I mean, if I told you 13 million, would that be something that you would, sounds about right?
Again, I couldn't say.
And how many witnesses, did the defense need to digest? How many possible trial witnesses did the defense need to digest?
I don't think we got to, because the court obviously didn't
Right.
accept that trial date, so I don't think we got to that question.
And how many hours of video footage?
You mean like footage at the Capitol of the attack on the Capitol?
Just how many hours of video footage, if the defense was going to take that to trial in 4 months, how many hours of footage would they need to digest?
I'm just trying to think if there was any video footage other than the footage of the attack on the Capitol. I can't answer that. I don't
President
recall.
Trump's defense team, indicated that it was like thousands of hours of video. And so to digest thousands of hours of video, to digest 13 million pages of documents, would have put them in a situation to, either A, not review the documents, or B, they're looking at like reviewing 100,000, pages per day. I mean, do you think that's reasonable?
I thought the trial date that we proposed, given the case, given the discovery, was reasonable, yes.
So if the math works out that they had to digest about 100,000 pages a day, you think that's reasonable?
I don't know if that's the math, and I don't know if that's the proper way to measure it, but I do think the date was reasonable.
And while all this was going on, and we went into this a little bit before, but you have the DC case going on, you have the Florida case going on, and you know that President Trump is required to be in Manhattan for the District Attorney of New York case. At any point in time, did you stop this? Stop to think that maybe you should have given him a little bit more time to deal with all these cases, these competing cases?
Well, we thought through the dates we asked for. We thought they were reasonable. We also deferred to the judges. So when we asked for a date and the judge picked a different date, I don't recall that we objected to that date.
A lot of times, though, the judge just splits the baby, right?
Well, I don't know that that's always the case. Sometimes they pick the date that one party says, sometimes they pick the other, sometimes it's in the middle, so.
Judge Chutkin certainly picked a date closer to yours than the 2026 date. Getting back to the Robert Jackson, statement that I read this morning, he concludes that a sensitiveness to fair play and sportsmanship is perhaps the best protection against the abuse of power, and the citizen's safety lies in the prosecutor who tempers zeal with human kindness, who seeks truth, not victims, who serves the law and not factional purposes, and who approaches his task with humility. Do you think in hindsight that you exhibited the kindness in dealing with President Trump that Robert Jackson evinces here?
I think in our conducting both of these investigations, we did it consistent with the best traditions of the department and the principles that Justice Jackson was talking about there. So yes, I do think in both cases, we adhered to those principles.
And is it also fair to say that you were, in fact, trying to get these cases wrapped up before the election in 2024?
We were trying to move these cases expeditiously. In our briefs, we cited to repeated Supreme Court precedent that states that the interest in a speedy trial, the right to a speedy trial, isn't just the defendant's right, it's the public's right as well. And given the gravity of these crimes and the public interest, it was our duty to move them forward as expeditiously as we thought fair and reasonable.
Okay. So in hindsight, there's nothing about the aggressiveness of your schedule that you would have done differently?
I thought the schedule was appropriate.
I just have a couple other questions. I'll jump around and I'll be done. Hopefully I can do that very quickly. The Florida case, initially, you had a grand jury operating in Washington DC. How does that work? You're taking evidence in DC for a case that, you ultimately decided to venue in Florida. Were you able to use the material from the grand jury in DC for the case, or did you have to repurpose that? Did you have to recirculate that material through a grand jury in Florida?
Mr. Castro, I'm sorry, I'm a little concerned that questions about the grand jury in DC and the Southern District of Florida may implicate both 60 issues and the scope of Judge
Okay,
Cannon's
fair
order.
enough. Can I ask hypothetically then, if you have a case that you're operating a grand jury in the District of Kansas, and you decide to move a case to, the Central District of California, how would you ordinarily, what's the department's posture on that?
In what sense?
So you have a grand jury operating in Kansas, and you collect evidence. Are you allowed to use that evidence if you ultimately decide to venue a case in the Central District of California, collected in Kansas?
Yes.
Okay. And are there any concerns about that?
You're speaking about a hypothetical case, but I think we're kind of speaking about the case in Florida, and so I think whether there would ever be concerns depends on the specific case we're talking about. And again, I don't feel comfortable answering that because of this injunction, but for the injunction, I'd be happy to answer it.
Okay. Mr. Jordan wanted me to point out that there was a discussion earlier, I think it was with Congresswoman Scanlon, talking about the Pennsylvania election. And I think you used the term that, in the normal course of things, the, things that happened in Pennsylvania. Am I jogging your memory with this?
I know we spoke about that. There was another series of questions about this, so I do remember that, yeah.
Okay. And we just wanted to point out for the record that, there was nothing normal about what happened in Pennsylvania during the 2020 election. The state legislature, who ordinarily is responsible for making, the election law, picking the time, place, and manner, and prescribing the blow-by-blows in an election, was basically usurped by the Pennsylvania Supreme Court. And they changed all sorts of things in the 2020 election. For example, they said that the election, instead of ordinarily would end on a Tuesday, election day, was going to end on a Friday. The Supreme Court said that where signature verification was ordinarily required, that was the Pennsylvania state legislature's, that's how the statute's set up, in terms of administering elections. And the Supreme Court changed that and said that, signature verification wasn't required. The volume of absentee ballots was completely different than an ordinary election. There were over 2 million, absentee ballots. And so, we just wanted to point out, and I guess ask you the question, were you aware of all these irregularities and disparities because of the COVID and so forth? So many things had changed by the time it got to election day in Pennsylvania.
Well, what I can say is that some of the issues you raised are the sort of issues that a campaign or someone who's a candidate can raise in the courts, and I believe a lot of these issues were raised in the courts. I think Donald Trump lost those litigations, and as we pointed out in our indictment, that bringing a lawsuit for some of the issues you talked about, that's the proper way to dispute these things, or asking for a recount, as President Trump did in 2 states. Our case was about false allegations of fraud. Our case, we did, the things you just mentioned, we didn't allege those to be part of the fraudulent conduct targeting a government function. And so, again, those are issues that I think we were aware of in studying these things and in speaking to election officials there. But they're the sort of issues that are dealt with through litigation in our court system, and I think that's what happened in the election after.
Okay. Let me go off the record briefly. Recall any discussions with public integrity? This is in the toll records topic area. Any back and forth with public integrity about acquiring toll records of staff, congressional staff?
One of the subpoenas we asked for was for a staff member. That's yes.
Okay. And do you remember House or Senate?
House.
Okay. And do you remember who it was or what the circumstances were?
I do. It was a staff member for Congressman Gomer.
Okay. And that was the only time that you saw toll records for a staff member?
That's my only recollection as I sit here now, yes.
We can go with records.
So, Mr. Smith, you spoke earlier today about threats and attacks against, made by Donald Trump against witnesses, prosecutors, judges who had challenged him, including threats against yourself. Do you remember that?
Yes.
So, did President Trump target you personally in posts on Truth Social?
Yes.
Are you aware, for example, that he called you a, quote, deranged lunatic, unquote, quote, Trump hater, unquote, and, quote, psycho?
Yes.
Do you recall that on October 15th this year, President Trump speaking to reporters standing next to the Attorney General and the Deputy Attorney General said, quote, deranged Jack Smith, in my opinion, is a criminal, unquote. Then he also talked about investigating Lisa Monaco, Andrew Weissman, and Adam Schiff, saying, quote, I hope they're looking at all these people and I'm allowed to find out. I'm in theory the chief law enforcement officer, unquote.
Yes, I'm aware of that.
And are you aware that President Trump posted on Truth Social on October 29th of this year that, quote, these thugs should all be investigated and put in prison, a disgrace to humanity, deranged Jack Smith is a criminal, with 3 exclamation marks, unquote.
That may be. I know there were several posts like this.
Okay. Do you think those were a direction, potential direction to the Department of Justice to retaliate against you because of your role as special counsel in the investigation of him?
Yes.
You are joined by your counsel today from Covington and Burling, is that right?
Yes.
And did President Trump or the White House take any actions against your attorneys due to their relationship with you?
Yes.
And what action did they take?
They filed an executive order against the law firm and sought to withdraw the security clearances of my attorney.
Okay, I'm just going to offer this as Exhibit 20, and this is exactly what you just talked about. So, Exhibit 20 is an executive order issued by
I know it.
the White House on February 25, 2025. And it is entitled Suspension of Security Clearances and Evaluation of Government Contracts. And I just want to read into the record that this executive order says, I hereby direct the Attorney General and all other relevant heads of executive departments and agencies to immediately take steps consistent with applicable law to suspend any active security clearances held by Peter Koski and all members, partners, and employees of Covington and Burling LLP who assisted former Special Counsel Jack Smith during his time as Special Counsel, pending a review and determination of their roles and responsibilities. if any, in the weaponization of the judicial process. And the executive order also directs the Attorney General and heads of agencies to take such action as are necessary to terminate any engagement of Covington and Burling LLP by any agency to the maximum extent permitted by law and consistent with the memorandum that shall be issued by the Director of the Office of Management and Budget. Did I read that correctly?
Yes.
To your knowledge, is this executive order still in effect?
I believe it is.
What do you think was his purpose for issuing this executive order?
To seek retribution against me.
Is it also to harm your relationship with your attorney and to make it more difficult for lawyers to represent you?
I think it's to chill people from having an association with me.
I just want to say for the record, we're still here, proud to represent Jack Smith.
Thank you. So once President Trump took office, were members of the special counsel's office, was their employment affected?
Yes.
Were they fired?
Yes.
Do you know roughly how many people were fired?
I don't have specific numbers.
Is it more than a dozen?
I believe so, yes.
Okay. Do you know who fired the former members of the special counsel's office?
You mean who told them or who issued?
Yeah, who actually communicated? Well, let's break it. Do you know who authorized the firing of these staff members?
I'm assuming the president did. I don't know the specifics, but
Okay. Do you know how the termination messages were communicated?
I don't recall if how they were communicated.
And these are career attorneys and agents, is that right?
That's correct.
Okay. They're not political appointees. They've served different administrations with different political parties at the head. Is that right?
That's correct.
Do you know what justifications were given for terminating those staff members?
My understanding is no justification was given.
Are you aware of any reason to target these individuals besides their work on your investigation or association with your investigation?
None. I think it's a travesty.
Do you believe, well, you just answered it, but do you believe it's proper to retaliate against career prosecutors for their involvement in a federal investigation?
Of course not.
What about the support staff who aided those prosecutors?
I don't understand that, why you would do that.
And what about FBI agents who carried out this investigation?
As I said earlier, I don't understand why someone would seek to do that.
Do you think that firing all of these public servants make the country safer?
No.
Why not?
As I mentioned previously, I think when you fire people who are career public servants serving both parties over many decades, you lose the expertise about how to do the job properly, and that has an effect on the department today, and it'll have an effect on the department for some time if those people aren't there to be leaders and to teach young lawyers how to be public servants.
Do you feel like you have a target on your back?
I believe that President Trump wants to seek retribution against me because of my role as special counsel.
Would you be surprised if President Trump directed the DOJ to indict you?
No.
Are you concerned about the safety of people who associate with you, like your former colleagues and your attorneys here today?
I would prefer, if it's all right, not to talk about my safety because I think doing so could in fact endanger my safety and those of people around me.
Understood.
I'm going to turn a little bit to the folks who actually attacked the Capitol on January 6th. I believe your report talks about the rioters, the crowd that violently attacked the law enforcement officers attempting to secure the building on page 25 of your report. One of those rioters was Daniel Rodriguez, who multiple times plunged a stun gun into the neck of Officer Michael Fanone, causing Officer Fanone to suffer a heart attack and sustain other injuries. Mr. Rodriguez was subsequently sentenced to 12 years in prison after a federal judge called him a, quote, one-man army of hate. Are you aware of President Trump pardoning Mr. Daniel Rodriguez?
Not him specifically, but my understanding is he pardoned all the people who violently assaulted police officers that day.
So in pardoning all the people who assaulted police officers that day, another example is a Mr. Patrick McCaughey III, who used a stolen police riot shield to crush Officer Daniel Hodges in a metal door frame at the entrance of the Lower West Terrace Tunnel, and he left Officer Hodges trapped, bleeding, even crying for help from his fellow officers. Officer Hodges testified, and this is a quote, if I was there much longer being assaulted in such a way, I knew that there was very likely I wouldn't be able to maintain my consciousness. Judge Trevor McFadden described Mr. McCaughey as a, quote, poster child of all that was dangerous and appalling about January 6th, stating that his actions were, quote, some of the most egregious crimes ever committed that day, end quote. Mr. McCaughey was sentenced to more than 7 years in prison. Are you aware that Mr. McCaughey was one of those rioters who assaulted law enforcement on January 6th that were pardoned by President Donald Trump?
Again, I don't know his specific name, but I know people like him who did things like he did were pardoned.
And are you aware of the more than 140 police officers who were injured by the pro-Trump mob on January 6th, sustaining injuries such as cracked ribs, traumatic brain injuries, smashed spinal discs, and heart attacks as rioters used bats, flagpoles, chemical sprays, stolen police shields, and batons to beat officers? Are you aware of those facts from that day?
Very much so.
Do you believe that pardoning individuals like this who committed crimes against law enforcement that day makes our country safer?
It does not, in my view.
Can you explain why, from your prosecutorial experience, prosecuting gangs, prosecuting violent crimes, why pardoning individuals who committed violence on January 6th doesn't make our country safer?
Well, I don't think it's really my opinion. I think we've already seen some of the people who were pardoned go on to commit other serious crimes, and I don't have much doubt that in the coming months and years we'll see more of that. People who would otherwise be incarcerated, communities protected from them, they're going to be out in communities, and my view is that we will continue, unfortunately, to see people who were pardoned for committing violence on January 6th continuing to commit additional crimes. That's my view.
Can we go off the record for a second? Were you aware that on November 10th of 2025, President Trump issued a second sweeping pardon proclamation granting a, quote, full and complete and unconditional, end quote, pardons to at least 77 individuals related to efforts to overturn the 2020 election? Were you aware of that second pardon from November 10th of 2025?
I was.
And many of these individuals that were one of these 77 individuals, they were individuals identified as unindicted co-conspirators in your investigation. Is that correct as well?
I believe that's correct.
Some of these individuals that were pardoned include Mr. Giuliani, who we talked about earlier today, who was willing to spread knowingly false claims and work to subvert the results of the 2020 election. Are you aware of that?
Yes.
I guess taking a step back and looking at the fact that President Trump pardoned these folks, these 77 individuals who were previously working to overturn the election, the 2020 election, what message does that send to folks living in the country, particularly as it relates to election integrity in future elections?
I just, I don't understand why you would pardon people who assaulted law enforcement. I think it sends lots of messages. One of the messages is to law enforcement, the people who defended the Capitol that day, in my view, are heroes. And I think pardoning people who assaulted them is wrong.
And what about pardoning the folks who actually worked on the conspiracy to overturn the election? What message does that send about election integrity to folks living in the country?
Well, I don't have a full list of all the people that he pardoned there, and so I don't want to speak generally about all those cases. We didn't charge anybody other than Donald Trump, and so I'm not going to speak about pardoning people who weren't charged with crimes.